hallway and checked to see if Mr. Hopkins is here?
Yes, I checked the hallways, the cameras, and probation, and no one has seen or had contact with Mr. Hopkins.
All right, the trial was scheduled to go at 9 a.m. It's now 9:20 a.m. Plaintiff's prepared to proceed.
We are, Your Honor.
Okay, I'll note for the record that Mr. Hopkins, has not appeared at the last few appearances, basically any appearance since the previous trial in this matter. So I don't anticipate he'll show up based on past history, but I wanted to make sure. All right.
And on that note, Your Honor, I have not checked the docket this morning to see if a motion to continue has been filed, but there was none yesterday.
Okay.
Just for the record.
All right. I've read the complaint. Do you wish to make an opening statement?
I've prepared a 5-minute opening statement if the court would entertain it, Your Honor. And before we begin, I have placed our limited exhibits that we wish to introduce on the witness stand, and Your Honor has a copy as well.
All right, very well. You can proceed.
May it please the court.
Mr. Ruddy?
Judge, let's just start with the elephant in the room. There's already been another trial in this case in which the jury awarded the plaintiffs a significant amount of damages. I want to stress before any testimony is taken that the causes of action being discussed today have no overlap with the damages awarded in the other case. The jury in that case awarded damages for a defamation which took place in 2023. This is a property dispute and contract from 2021. It gave no award for intentional infliction of emotional distress or loss of consortium, so some evidence was taken on these facts, but no damages were awarded. So with that backdrop, I'd like to just very briefly discuss what the plaintiffs intend to show the court at trial today. And more importantly, what we're not going to get into. The court's already established liability for abuse of process, which means in Ohio that the defendant has perverted a judicial process to achieve a wrongful result. It found the defendant breached the settlement agreement between these parties, a document which should have put all of this to bed in 2021. Now, the court has ruled that one of the specific ways that the defendant breached that settlement agreement is by creating a nuisance on his property, meaning the defendant intentionally created conditions which interfered with the plaintiff's ability to enjoy their own home. The court's also previously ruled, of course, that the defendant's refusal to respond to discovery requests was grounds to enter an admission to those requests. Among those admissions, I'd like to note, were that the defendant intentionally created loud car noises, stacked refuse along the property line, failed to maintain his lawn, and shone spotlights directly in the Goebbels' bedroom after the settlement agreement, along with a host of admissions that the defendant knew his defenses and counterclaims in this litigation were unfounded. He admitted specifically that the deed in this case was not illegally rigged, and he admitted that nobody told him that the restrictive covenants in his deed were illegal. That's
legal pad. I'm sorry.
Would you like me to pause?
You're fine.
Okay. This is on top of the summary judgment and default judgment entered in this case. Those are specific findings in the record. In short, the record is replete with the defendant's misdeeds. With that backdrop, plaintiffs are simply here to describe the damages that the defendant has caused them in terms of their emotional impact and just stress caused to the plaintiffs. Attorney's fees are appropriate in this case as damages both for the abusive process and breach of settlement agreement, along with an award of punitive damages. The court's already heard testimony on that issue, and I believe it will issue an appropriate award. I'm not going to ask the plaintiffs to reiterate that argument today or touch on any of those issues. The sole remaining decision for the court is the amount of damages for the nuisance and whether or not punitive damages will be awarded. The court's heard a great deal of testimony along with the evidence already in the record. The court has heard a lot of testimony about the nuisance the defendant caused. And we'll attempt to limit repetition of that testimony. But the reality is that the record in this case is not as well developed as some of the other cases that these parties have gotten into. So we'll have to pull some of that piecemeal evidence together today just to discuss the damages that were caused. At the end of the trial, it should be overwhelmingly clear that the defendant's actions have caused plaintiffs an extreme amount of emotional anguish, pain, suffering, and again, just stress. While it's already plain from the existing facts in this case, the unavoidable conclusion will also be that this was the defendant's intended outcome. He wanted to hurt the Gobles, so he did. The last factual question before the court today is whether or not the defendant was acting maliciously within the meaning of Ohio law. I'm going to read here. We won't have jury instructions in the case, so I've printed this out for myself. Malice in Ohio is a state of mind characterized by hatred, ill will, or a spirit of revenge. And if that doesn't sum up Mr. Hopkins in this case, I really don't know what does. We'll move as quickly as we can. We appreciate the court's patience today. We hope to be done by noon. Plaintiff's first witness will be John Gurman. I'll go collect him from the hall.
I'm sorry.
The plaintiff's first witness will be John Gurman. I'll go collect him from the hall.
Yes, okay, thank you.
It's back right corner. This chair? Yep. All right.
I don't. Make a statement, so it's 31.
Okay.
The case was set for 9 o'clock till 4 p.m. And then we added cases starting at 1:15 because it was anticipated that this case would not take all day. But if you get to noon and you're not finished, I'm not going to cut you off. Figure out.
I understand.
Okay.
I believe if we go over noon, something has gone wrong.
Okay, that's fine. Go ahead.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Sir, what is your name?
John Gurman.
How do you know the Gobles?
I've been mowing and taking care of his property for 10 years.
And
that's how I know them.
Sorry, after you.
I said that's how I know them.
How do you spell your last name?
It's Germann.
Thank you.
And 2 N's, Your Honor.
Yep, correct.
Mr. Gurman, you do that in your professional capacity, correct?
I do.
All right.
Two things. First, I called the forensic center to speak with Mr. Stewart, and he told me that he was not there. So I'm very happy to see him. I then later went to the jail and they told me he was at the forensic center. And I called again this morning and I was told again this morning that he's not there. So I'm very glad to see him. The last report I have is from December, which indicates that Mr. Stewart is still incompetent and not restorable. I called the forensic center and left a message to see if there was a more recent report, and I have not received a response. I would ask that the court continue Mr. Stewart under the orders for restoration.
All right. I will adjourn his competency hearing. I will adjourn that. Give me a date. Give me a first date in June.
June 4th.
4th?
Yes.
June 4th, 2026 at 9 a.m. We'll move that date up if necessary.
Thank you.
Thank you. Did you have something? Yes, sir.
My name is Crystal. Hold on, let me get off there. My name is Crystal, and Mr. Stewart is actually at Walter Reuther. That's why they keep giving you the runaround. He's at Walter Reuther and should be completing the report. Should have it by the beginning of May. That's when it's due again.
There should be a report by the beginning of May.
Yes, yep, it's one coming up.
Then let me change that date. Give me mid-May as the date.
May 14th.
I'll adjourn it then to May 14th, 2026 at 9 a.m. All right. Thank you very much for that information.
Thank
You're
you.
welcome. Thank you.
On continue. Court does call the case People versus Michael Banks.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Bank, Your Honor.
Yes. Mr. Bank, can you state your name, please?
Yes, Michael Bank.
All right.
Your Honor, we've submitted a green sheet. We're asking for another brief adjournment. There is some discovery that we have signed an order to receive some video on this matter, as well as I need to meet with Mr. Bank via the Oakland County site. Talk to him briefly, but their site went down in the afternoon on Tuesday.
Got it. How much time did you want? How long is
Fine, Judge.
pardon?
2 weeks would be fine.
Would be okay. All right. Probable cause conference will be adjourned to the 16th.
Thank you, Judge.
April 16th, 2026, 9 a.m. Bond will continue.
I'll set up another meeting, Mr. Bank, okay?
Okay, thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Derek Hunt. Oh, good morning.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning.
Morning, Judge. Brian Bowling on behalf of Mr. Hunt, who hopefully should be present on Zoom.
Mr. Hunt, you have him. Mr. Hunt, you'll have to talk so you come to my screen. Where do you have him?
He's not unmuted.
Okay, but where do you have him?
I know he's bonded out, Judge.
Got it. I got you. Then he's not responding. Derek Hunt?
Yeah.
Okay. He's on now. State your name, sir.
Derek Hunt.
Right.
Judge, I'm asking for an adjournment in this matter. There's kind of a condition precedent, if you will, that Mr. Hunt needs to complete to make the plea offer, essentially to trigger the plea offer. This case, making a payment. He just needs a little more time. So if we could get a little more time, that would be appreciated.
All right. How much more time would you need?
Month.
Is there any objection from the people?
Judge, I'm wondering about the bond in this matter. My notes say that Mr. Hunt paid a $49.47, so $4,947 cash bond. And I know that you do have a mechanism to get that immediately paid over. I assume Mr. Hunt wants to pay that over.
Well, whether he wants to or not, the condition of his bond is that it would be paid on the case. So if it was paid in, it should get over there. And I do see the bond. And what we will do, Mr. Attorney General, we'll contact 15th to see where that is in process and why it hasn't gotten over there if it hasn't.
And just for the record, the amount that he would need to pay to trigger the plea offer is a little more than what the bond was that was posted. So he just needs a little more time for that, Your Honor.
All right.
Right. And brother counsel there, I don't know if it's about $2,500 more is what I calculate. Very close to $2,500. Then you'd get to that delay point where we can potentially end up with a simple misdemeanor.
Yeah, that's correct.
Okay.
And my staff checked, and the check was cut February 10th. So that's at 15th District Court. I would be a bit concerned too if it was cut then, why it's not showing up. But what we'll do is we'll send an email and then communicate to the parties where that may be.
Perfect.
All right.
Thank you very much, Judge. And brother counsel, $729 a month is his monthly obligation as well. So
He's aware of
gotta
that.
be paying that. Great. All right. Nothing more from the people, Judge.
All right. Probable cause conference will be adjourned into May 7th, 2026, 9 a.m. Bond will continue. All right.
Thanks, Judge.
Thank you, Judge.
Thank you. Court calls the case, People versus Warner Ali Thomas. Was that it? Ready, adjourned? Oh.
Good morning, Your Honor. Assistant Public Defender Davi Lieb on behalf of Mr. Ali Thomas.
Your name?
Warner Victor Ali Thomas.
And Your Honor, Mr. Thomas would like to, Ali Thomas would like no contest in this matter. We're going to be requesting adjournment to get the paperwork in order for that.
I'm sorry?
Mr. Ali Thomas would like to plead no contest. I've discussed it with Mr. Hawthorne. We're going to be requesting adjournment to get the paperwork together for that.
Yeah, I have a plea form of guilty, but you're trying to change that and you have to get the paperwork in.
Yes, Your Honor.
Is he being held on anything else?
Yes, Your Honor.
Surrounding house yesterday at 2:00. I did not.
That's fine. All right. I will adjourn this out then 1 week so we can try to get this thing done to the 9th
Thank you.
at 9 a.m. Thank you. Bond, continue. Courthouse case, People versus Aisha Anderson, 3 case.
And your agreement for people.
Assistant Public Defender Jay Ballinger on all matters not ending in 5330, Your Honor.
Why do you do?
Because it annoys you.
I appreciate your honesty. All right.
And Sherilyn Foster Tucker, on behalf of Aisha Anderson in the remaining case.
You're like together on this. And Miss Anderson, state your name, please. Thank you.
And Your Honor, our client is at the home and
I see talking to me. Your noise being. No, go.
our client is at the home and New Vision currently. However, in speaking with her, it's our understanding that she does wish to set these matters for preliminary examination. To our knowledge, all discovery is complete.
That is correct.
All right. And would the people have their witnesses on the 14th?
Sure, Mr. Your Honor.
Preliminary examination will be set for April 14th, 2026, 9 a.m. before Judge Moore.
And Ms. Anderson, you understand that you do need to be here in person.
That is in person.
Yes, it's at that courtroom, right?
It's at the 14A1. Same courtroom you've been.
That building. Okay, yeah, all right, absolutely.
All righty.
Thank you, Your Honor.
Thank you, Your Honor.
Courthouse case versus Jacob Dorson.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Gorston, Your Honor. He's approaching the bench.
Your name, sir?
Jacob John Dorston.
All right.
I'm there.
What are we doing?
Your Honor, the people have made an offer. Mr. Dorston is going to plead guilty to retail fraud, third degree, PAC code 750.356D4. He's executed. And the advice of rights right now that I've filled out all his pertinent information for him. I have gone over his rights with him. Stay signed.
There's a conditional bond violation.
Yeah, yes, Your Honor. I believe he picked up a new case. May I approach?
Has that been charged?
May we approach briefly?
May. Okay, I have it before me, a form that indicates that the defendant is going to be pleading and presuming guilty. That box isn't checked.
Oh, I'm sorry. Yes, Your Honor.
Charge of retail fraud, the 93-day offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. And there's an agreement. The defendant is agreeing to pay restitution in the amount of $7.99. That's the court's full understanding of the agreement.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Now, swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Jacob John Dorston.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud third degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
You wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
Doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes.
February 19, 2026, at the location of 317 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. What do you do at that location that makes you think that you're guilty?
Your Honor, may I have one, dear Mr. Dorston? Did you go into a drugstore at that location?
Yes, Your Honor.
It was before they were open, correct?
Yes.
But the door was open, correct?
Yes.
And you walked to the back and took one of the beers out of a 6-pack of Budweiser, correct?
Yes.
And you left without paying for that, correct?
Yes.
And you knew the store wasn't open, correct?
Yes.
Yeah, I think he's made the proofs for larceny of building, which is a higher charge.
Sir, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
April 24th at 8:30 a.m.
April 24th, 2026, 8:30. Court Judge Bond will. Thank you.
Thank you, Your Honor.
Okay. If not, they'll come. Okay.
Okay, thank you. Court does call the case of the people versus David Barth.
Good morning, Your Honor. Jasleen Singh on behalf of defendant David Barth.
Mr. Barth?
David Barth. David Barth.
All right. Thank you. What are we doing?
Your Honor, discovery in this case has been quite a difficulty. So I have reached out to the assigned prosecutor, Mr. Daoud, a number of times. I do believe at this time that I have enough of the substantive discovery, meaning the forensic interviews and my client's interviews, as well as the police reports, but I have not received any indication from the prosecutor's office in terms of if there is body worn cam, in-car video, or any search warrants and their returns forthcoming. So I know my client is eager to have his preliminary exam. It's been over almost a year since he's seen his children, Your Honor. So we are requesting an exam date at this time.
Well, has discovery been requested?
It has been.
And we've sent for all the discovery twice.
You sent the discovery twice. How long is it going to take to get the body cam?
I would say it's 2 weeks.
So at this point, discovery isn't complete. What's the holdup with the body? I guess I don't understand.
I just sent a request, Your Honor.
Okay, no, but why wasn't it, I guess, why wasn't it accomplished before now?
It was just requested, Your Honor.
Okay.
I didn't have those body cams.
You didn't have the body cams. Council just requested it and you just sent in the request. Okay.
There is body cams that are already, I don't know if there's additional ones, that's no problem.
Well, I typically am not going to set a preliminary examination until discovery is complete, but if it's being requested, then here's what I'm going to do. Today is what? You're going to have that in 2 weeks?
Yes.
Extensive body cam? How many?
I'm not sure.
Have no.
There's any more available, so.
Would you have your witnesses available the 28th?
Yes, Your Honor, I'll do my best.
Then I'm going to set preliminary examination in this matter in person, April 28th, 2026, 9 a.m. That's before me. And usually I expect, counsel, that discovery will be worked out between the parties before it really even hits me, but I guess. 28th, 9 a.m. before me. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Kristen Luckett.
Sorry, Your Honor. Michael Gaddy, public defender on behalf of Mr. Luckett.
Your name, sir?
Christian David Lockett.
Requesting a forensic.
Yes, Your Honor. I believe Ms. Yagi has met with Mr. Luckett and also submitted the appropriate paperwork.
Yes. Forensic evaluation is hereby ordered. I'll set a competency hearing for July 2nd, 2026, 9 a.m. Bond will continue. Thank you. Court calls the case of the People versus Dontrell Smith.
You sure there's a bring on the people?
I have Yagi.
Sorry, Your Honor, that's me.
Mr. Smith, can you get somebody to turn? Thank you. Mr. Smith, state your name, please.
Dontrell Smith.
Thank you. What are we doing?
Your Honor, this is a date and time set for a competency hearing. We have received the report. Don't have any additional evidence.
Anything else from?
I want my probation, everything.
For one.
I'm sorry, I had him confused, Your Honor. Yes, all we have is a letter dated March 26th.
All right.
We don't have the report.
Do we have any indication when?
Have you reached out, reach anyone, Judge?
So they just got a visible police check right now.
What I'll do is.
Your Honor, we actually do have a report that's March 26th. The court doesn't have, may we approach it? I haven't.
No, she put a warrant out.
Don't have a report.
Down there, you put a warrant out for me. Washington County put a warrant out for me. You know what I'm saying? The Competency County didn't put a warrant out for me. So.
Deputy, how are we doing with jurors?
Am I able to ask you a question?
Not at this point because the attorney has left the room. If you can catch him and bring him back in, you can certainly reapproach the bench.
Thank you.
We're still missing a few, Judge.
Okay.
And breakfast, it was running a little late. Mariah said to get with the party and breakfast coming up.
Okay.
Mr. Finley, thank you for coming back. The parties have a question for the court, and I didn't want to do it without you being present.
Yes. Thank you.
Maybe let's go back on the record.
Oh, I'm sorry. The question was, we're not trying to dispute the amounts owed or anything. We're trying to pay it. The problem is we have a pending suit where there's a contract that we did that they're on us over 140,000, and the capital that we used from Etria was probably around 30, and I think we paid off. We were paying it off according to how it was set up, and then once we got into this, these guys defaulted on the payments and all that. Everything went down. So we've told them we want to pay, but we're trying to set up something where we can pay so we can still keep afloat, because we lost a lot of our capital. So now I don't know how to go about it. We're not fighting
So there are two issues here. There's the issue that there is a court case, and I've got to follow certain procedural rules when a corporate entity is involved. That's the issue with your LLC not having an attorney. Hopefully you'll get an attorney in the next 30 days.
Okay.
There is nothing that prohibits you outside of this courtroom from speaking with Mr. Finley or his folks and trying to come to a resolution. You can certainly do that freely without an attorney if you wish to do that. I just can't have filings being filed on the company's behalf without them being signed by an attorney.
Okay.
So if you all want to talk out in the hallway before you all leave today, that may be fruitful. Mr. Finley, I don't know what authority, if any, you may have with you, or if there's another decision maker that they should talk to, but perhaps you all can talk before you leave the courthouse today.
Okay. Okay. Thank you.
Okay.
Thank you, Your Honor.
Thank you. Y'all have a good day. This was said at 9. We're filing the notice at 9. Can you guys send the file?
Your name?
Corey Sleep.
You're here for a show cause, ma'am. Hope you have this money. We got a problem. How many times can we give you a break? Seriously. This ticket was issued in August of 24. We show caused you. You were supposed to be here December 5th of 24. You didn't show. We issued a bench form. June 24th, you came in here of 25. I told you to pay 75 per biweekly beginning July 8th of 25. You told me you could do that. You didn't do that. We issued another show cause for December 18 of 25. You didn't show up for that. We issued a warrant. And I told you, if you didn't have the money to call the court, they got better things to do down there than to simply issue show causes and warrants. I don't know what you're doing. Are you not working?
I'm working.
Where?
Medical city. It's facility. I'll be before you on Monday. I'm making excuses. I'm making an election.
Slow down. You'll be before me on Monday for what?
Be addicted every month. I'm gonna go to court.
It's not my courtroom. Thank you for flattering me, but it's not my courtroom.
So, the very paper trying to have another ticket for a 16-year-old who was vaping twice. I've been working on that ticket. That's where I've been putting money because
You need to come and talk to me when you don't have the money. That's what you need to do. I told you that before. All I expect is a little bit of courtesy toward the system. You're not showing any. You set up your payment plan again. I'll let you go again. But if you don't come back next time with your payment, or at least the courtesy of Judge, I need an extension. If you walk in here again or are arrested, you're going to do this jail time. Do we understand, Mark?
Yes, I understand.
Tell me when you can pay this. I'll set you up on a payment plan and we'll go from there.
Just need the payment to be lower. I'm working on.
I didn't, you can set up, you're the judge. I'm gonna let you pay up, I'm gonna let you set up your own plan. Tell me how much you can afford to pay.
Pay 20 on this one because I'm paying.
Ma'am, I don't need to hear about other cases. Pay 20 when?
Pay 20 to that
And then how much per week?
every 2 weeks until I.
How much can you pay them? 20? What days do you get paid?
We have to pay another 20 at the pay Friday. Tomorrow.
Here's what I'll do. Pay 20 today. You get paid on Fridays, every other Friday, right? Tomorrow is April the 3rd. The next time you'll get paid will be April the 17th after tomorrow. I won't start with payments until April the 20th. So you pay 20 today. You want to get ahead of it by one payment and pay 20 tomorrow or Monday, that's up to you. I'm only ordering you to pay 20 per week, or bi-weekly rather, starting on April the 20th. Now, if you don't have the money, what are you going to do? And then we're going to go on Zoom, right? You know how to use Zoom? That you were the one who Zoomed in. Well, you didn't have a case scheduled yesterday, right?
It was good.
That's what I'm gonna do. I don't care if we have to extend your payment time 48 times. But please do not ignore us again, okay? Good luck. Felsen, Timothy James Felsen, 26F245696. Morning, sir.
Morning, Mayor.
Your name?
Timothy James Paulson.
You're charged with disorderly public intoxication. Public intoxication. You have the right to a lawyer.
Okay.
Would you like a lawyer?
I'm sorry.
Would you like a lawyer to bring?
Yes.
Okay, so we'll set you up with a lawyer. And you'll go talk to him or her, and then you'll come back in with them, okay?
Okay, thank you, Mayor.
Good luck. Pratt, Kevin Pratt. People against Kevin Allen Pratt, 26F245858 A and B, your name?
Devin Allen.
All right, you're charged with drive while license not valid. You have a second charge here of improper plate. You have the right to a lawyer. Would you like one? Okay, we'll get you a lawyer, go out in the hallways, and you can go out in the hallway too, sir, and we'll set you up and you'll meet with the lawyer. The lawyer will meet with the prosecutor. Then the two of you will come in here. People against McCarthy. Terry Paul McCarthy. 24F242928. Your name?
Your Honor, Terry Paul McCartney.
You're another one.
Yes, Your Honor.
What are you doing?
I made a payment last month.
You know, but
I'm on social security disability.
I don't remember that. I mean, you give me more credit than I deserve.
Yes, I have a traumatic brain injury.
Okay.
I'm working with,
All right, fine. Relax.
Yes.
Heather, does he owe 219 now?
194.
How much of that can you pay today?
40.
I mean, you realize we've given you multiple chances, right? All right, fair enough.
May I speak?
Yeah, sure. Yeah.
So the last time I came in, you said something that, maybe community service.
You want to do community service in lieu of this?
So I live, close to an hour away. Would I have to come down here?
No, you can do your community service anywhere you want to.
Yeah, Your Honor.
You live in, what is it, Westland?
I live in Garden City.
Garden City. I'll let you do community service.
Yes, yeah, I've been unsuccessful with my vocational specialist. I would like to opt to community service.
Okay, here's what I'm gonna do. You said 199, right, Heather?
194.
194. All right, you paid 20 today. That'll bring your balance just 174, okay? Now, I'll tell you what, in light of everything here, you complete 11 hours of community service or pay 174 by May 15th. You think you can set that up?
Yes.
You can go talk to probation if you'd like, and they'll give you some ideas. Okay,
Okay,
so we'll send you over there and you're all set, and I wish you well.
thank you, Your Honor.
So you got till May 15th, pay the 20 now, you do 11 hours community service, or pay the remaining balance, which would be 174 May 15th, okay?
Thank you for your grace, Your Honor.
All right, good luck to you.
Have a nice day.
You too. Jason Michael Cook Thomas, 24B146297A. Who's this in custody, do you know?
It's Mr. Golding.
Your name, sir?
Jason Thomas.
All right. You pled no contest to a moving violation causing serious impairment. I placed you on probation for 15 months. I ordered you to perform certain things, including a level 2 decision-based driving program. The charge here is that you failed to attend and complete that. If I find you, all right, James, Sadie, I'm gonna need some more probation violation sheets. If I find that you didn't pay, I'm sorry, if you didn't complete that program, if you plead guilty, or if I find you guilty, this would be your first technical violation. You could receive 5 days jail. Do you understand me?
Sir.
All right. Did you sign, read, and understand the advice or rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. You have the right to an attorney. If you would like an attorney, I will provide you with one at public expense. Do you understand that?
Yes, sir.
Would you like an attorney to represent you?
No, sir.
To the charge that you failed to attend and complete the decision-based driving program level 2 with Class A Training Center, how do you plead?
Not guilty, sir.
Did you do it?
I did attend. They did not start the class. And I did.
Hang on a
provide-
second, slow down. I ordered this in September of 24, right?
So I
Is that when I sent you?
I believe so, sir. I had.
Let's slow down. Just slow down. This is what, 17, 18 months later, 19 months later? I'm gonna have a hearing on this. We're gonna get Ms. O'Donnell in here, okay? I'll enter a not guilty plea for you. And we'll have a hearing right now, okay?
Okay.
So you can have a seat at that table right there. Thank you. I need Jessica in here. You have this gentleman's file, Ms. Patil. Okay, take your time. Morning. Jessica, come on up here, please. Recalling Jason Michael Cook Thomason, 24B146297A. Your name? Sir, your name again?
Jason Thomas.
Do you still wish to proceed without a lawyer?
Yes, sir.
Go ahead.
So he was registered for the class and did attend it last month. Class A had a malfunction with their servers and had to cancel the class for everybody. So they had to cancel the class for everybody and then had to reschedule everybody. He's now rescheduled to take it April 25th.
I know, but why is this going on so long? I ordered this in September of 24.
I know that it was probably a money issue for him in the past. This is the Ms. Tessino's case. I took over it after she left. So I assume it was a monetary issue before, but it seemed like he was gonna be able to get it done in time and he was there and ready to be done in time to be discharged, but then Class A had that issue.
Do you work?
Yes, sir.
Where at?
I'm a plumber or apprentice plumber. Actually.
I extended his probation once until March the 11th. And that was for failure to attend this driving program. And that hearing took place on October 27 of 25. Why are you waiting so long?
that time I couldn't pay for the class, and I've actually tried to take this class twice. I paid for it twice. The first time, I couldn't make it out there, so I couldn't pay for it, and then this time they didn't start the class.
I hope we're not gonna go through this again. I'm gonna dismiss the show cause, probation extended till June 11th, 26. You get this done, you'll be entitled to early discharge. Stop playing this with this though, will you please?
Yes, sir.
All right. You're free to go. Carl Kenneth Golding III, 22F 2338778.
Good morning, I'm Deanna Petito, Plea 82378 on behalf of Mr. Golding. State your name for the court, sir.
Carl Kenneth Golding III.
It's like every file now I pick up, you know that? You're supposed to be here in March of 23. I don't want to rush you. Didn't want to rush you here, you know what I mean?
Yes, sir.
What has happened? I don't remember it like this before. Maybe I'm just getting old and I've forgotten. 2 charges, failure to attend the court work program on February 11 of 23. Failure to pay fines and costs is ordered, balance owing 630. Those are the charges. How's he going to proceed?
To plead guilty with an explanation to both charges.
I'm gonna need Jessica on this one. Sir, if you plead guilty, since you absconded, you could receive in this case 90 days. Do you understand that?
Yes, sir.
You're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to have a hearing. At that hearing, you can remain silent. You can testify if you so choose. If you choose to remain silent, that silence would not be held against you. You have the right to cross-examine their witnesses, including probation officers. You have the right to bring in your own, to use the subpoena powers of the court to bring in your own witnesses and to testify, like I said, or remain silent. Again, if you remain silent, that silence would not be held against you. If you plead guilty, you're waiving all those rights and you're waiving the requirement that they prove you guilty by a preponderance of the evidence. Do you understand that?
Yes, sir.
You still wish to plead guilty?
Yes.
As to count 1. From the show cause dated March the 11th of 23 to the charge you failed to attend the court work program on February 11th of 23, how do you plead?
Guilty.
You failed to attend the court work program on that date?
Yes, sir.
To the charge you failed to pay your fines and costs as ordered, balance owing as of the date of the show cause is 630, how do you plead?
Guilty.
You failed to pay your fines and costs as ordered.
Yes.
Anybody force you to plead guilty or promise anything to induce you to plead guilty?
No, sir.
Plea is accepted to those 2 counts. So what happened? What is this?
So, Your Honor, he's currently in custody out of Tuscola for felony failure in possession. He's in custody because of a probation violation because he tested positive. He's not getting out. His hearing date is not until the end of May over there. And then even after
Hearing
that,
date on a probation violation?
Yes, as well as a possible new charge. I've been incarcerated since February 5th. My first court date was adjourned 30 days. And then
Mr. Golding, I don't need to hear any more right now, please. I'm just not, why am I not surprised that you're going through the system like this? It's shocking. Not. Jessica, your name?
Jessica Donnelly.
Have you ever heard from him?
Doesn't look like it. It looks like the last time I heard from him was when he was sentenced on this, which was back in, it looks like 2022 or 2023. He did complete one of the days in the court work program. He did reach out to me and stated he was injured at some point, so I did cancel some of his days. And then he was rescheduled for those 3 days and then missed them, and I didn't hear from him since.
then he also indicated back then he was residing in Oakland County. His license was suspended, so he didn't have transportation to make it to.
I hate that. He committed a crime here. He got here that day, didn't he? I hate to hear that. I don't have a ride. You don't have a very good record, Mr. Golding. Actually, I think you probably have bigger fish to fry here, to be honest with you.
His attorney in Tuscola is working on a 6-month in-treatment rehab program for him, but he won't find out about that until he goes back to court at the end of the day.
It's already been in February 11th, did you say?
February 5th.
It doesn't sound like he's going anywhere if they put that up, if they put that sentencing toward. Probation's revoked, you're sentenced to 45 days, credit 45. I hope you grow up. Good luck, thank you.
Thank you, Your Honor.
Thank you, Judge.
I'm sorry if I mispronounced this name, Sharon Michelle Shunky. 26F245-712A and B. Your name, ma'am?
Sharon Zunke.
You're charged with operating while intoxicated and driving on a suspended license, and you have the right to an attorney. Would you like one?
Do I look what?
Charged with operating while intoxicated. If I were you, I wouldn't represent myself. You want a lawyer then? Okay, we'll give you a lawyer. Go out in the hallway and you'll talk to the lawyer. The lawyer will talk to the prosecutor. Either way, you're coming back in front of me today, okay? Good luck. Gosh, why are we taking so long on this is Christine Francis Lozinski, 26F245-459. Your appearance?
Good morning, Your Honor. Leslie Aycock on behalf of the defendant who's present in my office to my right. Can you please state your name for the court this morning? Christine Lozinski.
Why are we taking so long on this?
We're requesting a brief adjournment. We are in the midst of plea negotiations. There's an issue that the prosecutor and I need to speak on a little bit more thoroughly. It might result in the filing of a motion. It may not. We'd request 2 weeks to be able to see if we can resolve it.
Last adjournment, okay?
Okay.
I mean, we've had about 3 or 4 of them pre-trials, haven't we? We had a pre-trial on the 3rd, then the 19th, then today, right? I don't have a problem.
I believe she was arraigned February 19th. Then we adjourned for discovery. And then
All right,
we
we'll
adjourned
set
again.
this for April 16th. April 16th at what time, Heather?
9:15.
At 9:15. All motions to be filed by April the 7th, okay?
Your Honor, that really doesn't give our office a lot of time. I mean, April 7th is next Tuesday.
I know, but you guys have had, that's what I'm trying to tell you nicely.
Well,
You've had 3 pre-trials and you have to serve it, at least if you're serving it by first class mail, you have to serve it by the 7th. If you're gonna e-file it and serve it on him, I can give you till the 9th, but
well, our effort is to see if we can resolve an issue. There's a pretty significant issue. We feel we may be able to resolve it short of the necessity of filing a motion. It's a stop issue. So I'd like to, if possible, perhaps avoid the necessity of filing a motion.
Call in Mr. Cayley.
And additionally, Your Honor, while we're waiting, my client does indicate to me it would be after our return date, but she has a work, out of town work commitment, April 22 through 27 in Lexington, Kentucky. It is a horse show. She works in the horse business, and we would ask for permission to travel.
Your appearance?
Well, you're on Ron Phillips, Deputy City Fleischer.
So I don't usually take a peek at police reports. I'm told there's a stop issue. And she's gonna file a motion.
That's fine.
But I don't know where the stop issue is. It says I mean, unless this is what the officer's saying, traveling on the roadway directly in front of the scout car, appearing to swerve over the lane marker line, separating the right and left lanes of travel. I'm sorry, I really want to move this on. I'm going to have you file your motion by the 7th. We're going to hear it on the 16th. If you do file a motion and it requires officers here, I expect them to be produced, and we'll move it to 11 o'clock. So she's not waiting around while I go through my
I'm
document.
sorry, I'm not available at 11 o'clock. I have a circuit court evidentiary hearing at 10 o'clock that morning on the 16th. Would 8:30 or 9 would probably work, but I'm
I
scheduled.
know, but
for
I
Judge
can't,
Abraham.
I can't, I'm trying to accommodate, but I'm not sure I understand why this wasn't done a month ago. I'm just not sure I understand that. I mean, we've had 3 pre-trials in the case.
Well, there was an issue with discovery the first time, then we
What was the
received
issue with
it.
discovery? You didn't get her
We didn't have
discovery?
it. We didn't have it.
Videos, Judge, I think.
All right, here's what I'm doing. I'm gonna adjourn it to the 30th, and I'm gonna set a jury trial then today too, okay? So all motions, give me a date on the 30th, Heather.
We can do the 30th at 8:45.
Well, I know,
It
but
would
if she's gonna
It'd have to be
file,
later. I have to be in circuit court in front of Judge Wanda Evans in person at 9 a.m. on the 30th, like maybe 11:30, if that would work for the court.
You have a
Court's
trial
still
at
on the 30th.
11. Oh, yeah, and you have a trial at 11.
We report to school at 9 on the 30th.
Okay, if you want to do it in the afternoon, on the 30th, if you. I don't think it's gonna be
Afternoon's fine
long,
with
Judge.
me.
I really don't.
okay.
Are you okay with that, Leslie?
Yeah, afternoon's fine with me on the 30th. Whatever works for everybody
April
else.
30th at 1:30, final pre-trial. I'm also setting a jury trial. Give me a date for that, Heather. All motions to be filed by April the 20th. Jury trial date will be, do I have something like on May the 14th?
We could do, the 15th is a Friday. Do you want to do the 14th or on a Thursday?
Am I here
Or- You're here on the 14th. Yes, Judge.
Yeah, we'll do the jury trial. Are you good, May 14th?
Yeah, that should be good.
You good, May 14th
May 14 works for my schedule. Thank you, Your Honor.
at 8:30, okay? Thank you. We'll see you guys here then. So all motions to be filed by the 20th, final pre-trial on the 30th, jury trial May 13th. And if you're gonna do, if we go to jury, we're gonna need the jury instructions within a couple, 3-4 days after that, but I'll worry about that later.
And luckily, if you can shoot me an email about what officers you want there, I'll get a hold of the officers.
All right?
Yes, I'll
Thank
get in
you.
touch with you. And then just, Your Honor, my request for travel for my client. She
Give
has
me
a
that
work.
file back.
I'm sorry?
I'm asking for the file back.
Oh.
Yeah, when are the dates? April 22nd, you said?
April 22 through April 27th, and she'd be
leaves-
traveling to Lexington, Kentucky for
I
work.
leave state between April 22 and April 27, okay?
Thank you very much, Your Honor.
Thank you.
Take
All right, Alyssa Young, Alyssa Leanne Young, 25B, thank you, both. 718619.
Good morning, Your Honor. Attorney Corey Westmoreland, bearing on behalf of Ms. Young.
All right,
Ms. Young, and please state your full name for the record.
Just the lady.
where is she then? She's just walking in today?
That's correct.
Why?
Your Honor, she had a real slow start to starting probation. She acknowledges that, but she walked herself in today.
Well, she didn't even get sentenced yet, did she?
Had a warrant issued that, I'm required to fix to get my children back on the 13th, so I'm walking in to try to fix the warrant. And get everything. I got a job, I got relocated into a safer home for me and my children. I had emergency court for them yesterday, and one of the requirements.
Slow down a second. Shannon, did you call over to probation, see if she underwent the screening? Did you ever undergo the screening over there?
I've never even had assigned a probation officer.
No, I know. Listen to my question. When I took your plea, I told you to go over to probation and get screened and assessed.
Yes, sir, I did.
You filled out the questionnaire and you were interviewed.
Yes, sir.
Have you been charged with anything or convicted anything since then?
No, sir.
It's gotten to the point where it's more common for people not to show up than it is for them to show up. Maybe that's my fault.
She's coming. Judge.
I don't understand this. This was serious business here. You had an OUIL and you had an occupant less than 16. And you had no business not showing up. Where does she work at?
She's currently working in the office, Your Honor. She's been there for roughly a month.
You've been going to AA? Of course not. Let's
I
see,
have from February.
let's see your proof.
I have a picture from February that I sent to the,
I told you to go starting on October the 14th of 25.
sheet that I had brought in from yesterday. I just,
From yesterday, were you in
I'm
here?
sorry, not yesterday. I was here yesterday, though. I did try to get a court date yesterday. You told me to come back today.
Ms. O'Donnell, your name again? I'm just trying to figure out if we did this.
So we
Sounds
did
like
do
we
the
did.
screening. One was completed, so everything is done there. It just looks like she didn't show up for Senate.
Can I see the screen, please? How many times have you been to AA?
I usually go on twice a week since I came back here.
Let's see your proof. Show it to your lawyer.
I'm just trying to record it. So I think that's one that I have.
You were supposed to go in person, so you should have handwritten signatures on a piece of paper that we gave you when I told you to go to AA. Where is it?
The last time I had came in here, I had showed you that paper. I had it in my belongings when I had relocated out of the home. I just took mine and my children's clothes and I left everything.
I don't remember anything about that, ma'am. I don't, you know,
I was here with the short guy and he had showed me the paper the last time I had court and he
Ma'am,
ordered me to go to
that was-
the middle school and do your credit work on the 22nd, but I missed it.
yeah, you were supposed to do their court to school program. You let me down.
So that was the last time when I showed you my handwritten papers.
Where is it?
Like I said, when we left the home for my kids' safety, we just took mine and my kids' clothes and I left everything else there. I literally stood up all my belongings in my
All right,
purse.
okay. Can't censor today. I need to review everything. I'm not gonna,
Get an apartment in 2 weeks and everything.
just relax. You haven't lost custody of your children, have you?
I did not, I lived with my sister until I relocated us.
Where do
I
you,
left full custody of all my children.
do you live in Inkster still?
I do not, right now I'm living with a friend here on West Road in Hall. That's why I work at the McDonald's on West Road. And my sister and I have my children in Newport.
What is the address that you live at?
25217 Carmel, Woodhaven.
Carmel?
Yeah,
CARMAMEL.
Yeah.
In Woodhaven.
that'll be just for the next 2 weeks until I get my apartment and we get.
You'll have to let us know. I'm gonna give you a new court date, okay?
Okay.
Just don't understand it. Sentencing date, Heather,
You want to do 2 weeks on the 16th, Judge?
sure, 8:30 in the morning. April 16th at 8:30. You're to continue going to AA twice a week, in person, no alcohol, no marijuana, no illegal drugs, no contact with prosecution witnesses. You cannot leave the state without consent or violating law. You must appear in court as directed, okay?
Good luck.
Caitlin Bianca Pack. 2-6-F-245-254. Where is she at? Caitlin Pack? She was here, right? She had to be. She signed an advice of rights. Is Caitlin Pack here? Okay, 26F-245-254. Your name, ma'am?
Caitlin Pack?
You're charged with operating while intoxicated,
Correct.
and you have the right to a lawyer. Would you like an attorney?
I'm actually waiting on my attorney. He should be here.
Did you hire a lawyer?
Yes, I
Who,
did.
who did you hire?
Sasha Khan.
Okay, so he'll have to file. Did we have an appearance from Mr. Khan?
No, I
Okay.
do not, Judge.
All right, so he's gonna have to file an appearance. Tell him, why don't you hand her one if you would, Sadie, and we'll go from there. Okay? You're sure he's coming?
Yeah, he said he should be here in a minute. He was caught in traffic.
Eileen Lynn Gettle, 267-245-458. You're gonna have a problem on this one.
What?
We're going to have a problem on this one. She's got two priors. She have two priors?
She did have some prior history, Mr.
Looks like,
Mr. Kelly was aware of that.
well, no, I'm not quarreling with the plea. I'm just, your name, ma'am,
Oh, I don't know.
and your appearance.
Sorry.
That's all right.
Jonathan Jones, 52960.
She got, I know they were a while ago, but this is her third offense. I'm not sure why they didn't charge her with the felony.
Right, I know you trust me, but I just want the record to reflect Mr. Kelly, and I did discuss that.
No, I'm not quarreling with your plea. But I'm not sure if this young lady isn't going to jail today, and I don't want to blindside you.
I appreciate that. She's been completely.
She live in Pinckney?
Yeah, she does.
You got a problem. I mean, she had a 259 here. I'm not sure why she's doing this to herself. She's got a better.
Oh, we're gonna talk about that, obviously, but
I'm just trying to tell you right now. If she gets into sobriety court, and I'm reluctant to take her into sobriety court because Pinckney's a long way from here, and that's gonna make it very difficult. I will likely not send her to jail. If she doesn't get into sobriety court, I'm probably going to send her to jail. But I'm not gonna talk about days or cops pleas or any of that stuff. I mean, that's a high breathalyzer, blood draw.
and that's why I thought the sober link was a great idea. You converted.
I'm just telling you where I'm going with this.
You know, that's why I say you converted her in person AA when we pleaded, and she's got proof of that. She's been.
I'm just telling you, she doesn't get into sobriety court. You want to talk to her about that? I didn't know about the third one.
Obviously, we can't do that this morning, right? That's gonna be a process that we play out.
If she tells me she's interested,
She is.
I'm gonna send her over there to talk to probation. And we would then start the bond phase today. And I'd have to adjourn the sentencing in about 5 weeks. So I'm more than happy to entertain her if she really wants to do it for the right reasons, but you gotta get off of this stuff, man. I mean, this is bad. I mean, you don't look 41, so I'll give you that, but
Yeah, it's amazing how young she was.
you got 3 drunk drivings now, and I was aware of the second one in 06 out of the first district court in Monroe, but I was not aware out of the one of Ohio, in Ohio in 09, and now I see that's in the report. So that's why I'm telling you that. If you want, she can go talk to probation, see if she's interested. I want to make sure she is because it's involved.
I just want to say, I know that, you know, I know that.
Right.
But what's great about these programs is that if someone is fully committed, she embraces the whole.
She will turn her life around.
Right. As my friend's father says, that we're easy, everyone.
Right. So you want to go talk to probation, man?
Yes, yeah.
If I may, because you can imagine I have other places to go. I mean, with the idea that she's committed in the screening and what have you.
Yeah, I know, but she didn't even know I was gonna bring this up.
No, I know, but I'm saying, can we get a new date now to address this one after she goes through the registration?
Well, what do you want to do? I mean, you might have assumed she's going to try to get into it.
Yeah, and we talked, she's wants to be sober and will embrace it. Yes, the drive is gonna be a nuisance and whatever, but again,
I mean, these are old, I'll grant you that. But nonetheless, she's gonna do a few days if she doesn't get in there. So I'll do sobriety, if she wants to do sobriety court, we'll put it out. sentencing in 5 weeks.
Yeah, what's that? I gotta finish up here.
No problem. What do you have, Heather? A date for me, say the second or third week in May, second week, let's say.
We have. You want to do it on a Thursday, Judge, or a sobriety court day?
It does not matter to me, in all honesty. There's
you
no
have-
act, there was no
Are-
accident here, so there's not gonna be any restitution.
So you have sobriety court on the 13th. If you want to do it on that day, we could do it Wednesday, May 13th.
At 8:30 in the morning. You good then? Mr. Jones?
Yeah, at 8:30 AM. I have something downtown, but I know I can do, come here and finish that and get us on. That's fine.
Okay, so we'll do May 13th at 8:30.
So we're just gonna walk across the probation.
And then tell them I sent him over there that she's gonna strongly consider getting into sobriety court. I want them to explain everything. If she decides she doesn't want to do it, then that's fine. Then I want you to call the court and we're gonna set up a sentencing real soon.
Okay.
Okay?
So, yep. All right, great to see you. Please have a good holiday.
You too.
I'll see you on the next one or back with her, whichever. Have first.
Take care.
All right.
Bye now.
See you.
Counsel, did you fill out the appearance?
Judge.
Okay, people against Caitlin Pack. Caitlin Bianca Pack, 260-245-254. Good morning, Mr. Khan.
Good morning, Judge. May it please the court, Sergeant Khan, P65487 on behalf of Ms. Pack, who is approaching her. Give me your hand for the record.
All right. Does she stand me wait for my reading?
Yes.
Enter a not guilty plea. We can pre-try this today if you want, or you can get a discovery order, whatever you'd like to do.
Discovery order, please, in the pre-trial.
All right, we're gonna give you a new pre-trial date. This was a blood draw, wasn't it?
It was.
That's why I had the order for prints here. She was never printed. She had any priors?
No, right, drunk driving, no.
She has a drug prior though, right?
It was 74.
But it wasn't, she pled under possession of some kind of controlled substance, true? All right, can you tell me what the alleged breathalyzer or blood draw was here, I should say? I was talking to your lawyer.
Yes, there was no alcohol present. There was, I believe it was Zoloft that was present.
Okay. Good. All right. Give you a personal bond, ma'am, of $1,000. You don't have to post any money. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm going to order that you abstain from the use of alcohol or drugs, no marijuana, no illegal drugs, no alcohol. I'm going to ask that you go over and get printed and photographed at the Flat Rock Police Department today by 11 a.m. And we'll give you an order for the prints. We'll give you your new court date. And also no contact with prosecution witnesses. Those are all bond conditions. Do you understand that, ma'am?
Yeah.
All right, so we're going to give you this to take down. So you can go down the hall. And they'll give you your court date, okay? And they'll send this order for prints over there, and they're also going to give you your bond sheet. I want you to go to AANA at least one time per week in person. Do you understand that? So at least once a week, every time you go, you have to have the form signed, all right? Anything else, Mr. Khan?
No, Judge.
If you want to get the discovery order from Mr. Cayley, I'll be happy to sign it. You can bring it back in here, okay?
I definitely will
Judge,
do that.
do you want that date?
Oh, I'm sorry.
Ask for the date.
Sorry about that. Go ahead.
April 16th at 9:15?
April 16th, 9:15. Good for you?
Yes, Judge.
All right. Once I have people around to catch my ears at the time. All right, that's what we'll do. Thank you.
Thank you, Judge.
You too. Good luck, man. People against Jeremiah Jolly. 26R514567. Is anybody on Zoom by that name?
No, there is not.
Prosecutor sent this in saying responsible is charged by default. Okay. So then failed to appear. This was scheduled for 8:45 and it's now 9:26. Defendant's in default. Did you need some?
Judge, I was gonna ask, we have permission to appear by Zoom. I think if she appears with me,
As long as she's in your office with you.
I just want to make sure.
Yeah, as long as you either both have to be in here or in your office together, okay?
Thank you so much.
Have a good day.
Silence.
I do.
Are you're a lawyer?
Next day, I was supposed to be off of probation last year in March. They wanted.
People.
Phoenix Saxon for Phoenix Born. He's the name for the court.
Phoenix Born. All right, you're asking for an adjournment.
I am, Your Honor. I have a bond argument.
All right.
Your Honor,
I will adjourn the matter April 6th, 2026, 9 a.m.
also
Bond.
April
16th. Bond.
Your Honor, Mr. Boers was arrested for being outside of the home and was on a house arrest with GPS tether. The reason he was outside the home, he was still in the same complex. And this was relayed to me by his mother. She forced him to leave because he lives in her house, has to follow her rules. His cousin died and they were doing a balloon release in the complex. And she, despite him saying, you know, I'm not allowed to leave, she was like, get dressed, get out, and let's go. Repeatedly, you're in my house, you follow my rules. And he did it. As the map shows from non-compliance or GP, he sincerely was, he really was not far from his apartment. And that is the reason he was not hanging out. And given the time shown from departure to return, it's lined up with the fact that it was a few minutes, the balloon release, and then he came back home. He did not go anywhere else, and he was on foot. So this is his first offense. He's 18 years old. He is a student. His mother also confirmed for me he is still in school. I'm waiting for a letter from the school showing that upon completion of this one exam, he will be finished as a senior and he would be able to graduate. So I'm asking for his bond to be modified to a personal bond with him remaining on the GPS tether. And now his mother has full understanding of what house arrest means.
How come he didn't respond?
I'm sorry, Your Honor?
He didn't respond when alerted. Why didn't he respond when alerted that he was in the zone? I mean, they send warnings and notifications and attempt to try to contact, and there was no contact.
Again, it was, you're going to be here, we're doing this release, period. It sounds quite cliche, I'm not being sarcastic at all. He was caught serving two masters at this time, the law and his mother.
Your response from the people.
I would leave this up to the discretion of the court. Certainly, I haven't been able to have contact with the father or confirm whether or not. Yeah, so it does come out. I trust counsel at her word and she spoke with the mother. I trust her on that. Those representations made to the court. I'll leave it to the court.
I do have the text messages from the mother that I'm willing to show prosecutor in the court. And but for transportation issues, she would have been here this morning.
In looking over the report, I guess he was out for maybe 10 minutes, but given that explanation, I'll grant the motion for a bond modification. His previous bond conditions, including the bond, is restored. All right.
We did have one additional matter with the defendant's bond being restored. I know the court sessions for April 16th. I'm requesting to get just a little bit longer than that. I anticipate there being additional reports forthcoming, and I don't know how long it's going to take. Plus, I just don't want to be in the back on 16th. We still don't have all the discovery work.
Got it. Any objection to that, counsel?
No, Your Honor.
I'll go to the 30th.
Thank you, Your Honor.
2026 90. Ron, can you, thank you.
Thank you.
All of it. Court does call the case, People versus Isidro, is it Ricarte?
Yes.
John Shea, Your Honor. Okay, who is on screen?
Sir, can you please state your name?
Isidro Ricorte.
Thank you.
Your Honor, first things first, there's been some confusion regarding between JIS and the complaint and about the spelling of Mr. Ricarte's last name. I thought we had it straightened out at arraignment, but apparently it may not have been. What does the court have?
Are you talking last name?
Yes.
I have his last name spelled Ricuarte.
And that's not correct.
That is not.
No.
Okay.
It is the A and the U are misplaced. It should be Ricaurte.
Got it. So what we will, but you thought you got it straightened out as a arraignment. So. Well,
I know I brought it to the attention of the court at arraignment.
right, but nobody. So his name is Ricua?
No, Ricau.
Okay. Well, this is weird.
The complaint was originally sworn out with the correct spelling.
Correct spelling.
Somebody
It was changed.
incorrectly.
So I'm presuming there's no objection from the people. All right. Then what I'm going to go ahead.
Corrected incorrectly. So if Your Honor needs something to identify and get that.
Now, what I'm going to do is I'm going to do two things. I'm going to make the correction on the complaint, putting it back to how it's supposed to be. then I will know. On our Caro that it should be corrected to RICAURT. Hopefully that will work. All right.
We've submitted a green sheet. There's discovery still coming in this case. We've asked for a 4-week adjournment to April.
Right. Will the 30th work for you? 30th?
Yes.
That objection, probable cause will be adjourned April 30th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Yeah.
Chico, I'll call you later.
Thank you.
Court calls case people versus the Varsier Henning.
Morning, Your Honor. Ring took the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Devasier Henning.
What are we doing?
Your Honor, I just received discovery at 8:51 this morning. I have not had an opportunity to review it or review it with my client, but because I do have it in my possession, I'm asking for an exam date.
All right. Has all discovery that's available been sent, just to make sure?
I've marked everything that we have for discovery, yes.
All right, I'll indicate that discovery is complete. Will the people have their witnesses available on the 14th?
I don't know, Your Honor. The victim on this, I believe, was hospitalized as an SPCC. I don't know his expected discharge date or how long he's expected to be in the hospital. If we could get, at the very least, Zoom accommodations for him, that might make it quicker.
Pardon?
If we could get Zoom accommodations for him, he might be able to appear from the hospital, but I don't want to disrupt his medical treatment if we can avoid that.
Your Honor, my suggestion would be let's set it for that date. Obviously, Mr. Cook and I can discuss the situation as it develops. My client's in custody. I want to get this moving as fast as
No,
possible.
well, I understand that, but yeah, that's fine. I'll set it for that day. I'll set it for the 14th, but that I will indicate in the file that the people will be entitled to an adjournment if their witness is not medically available. So you go ahead. I'll put that in. All right, Bond will continue. Thank you.
Did you indicate which judge, Your Honor? I'm sorry.
I'm sorry. It'll be the 14th before Judge Fleischer.
Thank you.
Court calls case people versus Rachel Plachette.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Pichette. Ms. Pichette, can you state your name for the record, please?
Rachel Pichette.
Thank you.
Thank you.
Your Honor, we are just asking for an adjournment of this matter. 2 weeks would be sufficient. There is a misdemeanor matter that is outstanding as well, and we're going to be working on a global resolution.
Probable cause conference will be adjourned April 16th, 2026, 9 a.m. Bond continue.
Thank you so much, Judge. Have a great day to you and your wonderful staff.
Say, thank you.
Thank you.
Court calls case people versus Tanisha Moore.
Morning, Your Honor. Ring.
Good morning, Your Honor. William Amadeo, P76194 for Ms. Moore, who will be approaching. Tanisha, when you get to up here, please state your name for the court.
Tanisha Moore.
You're requesting an adjournment.
Yes, Judge. I'm asking for a 2-week adjournment and to briefly be heard on bond. I was asked to take over the file last night. So I just want
Probable cause conference April 6th.
As the bond judge, I'm asking for a PR bond with GPS tether. I'm working on a plea right now, which will require restitution. She could get her job back if she is released from jail. She's been sitting for 12 days on the violation, on the bond, I should say, she couldn't afford.
Hang on. Can you? Thank you. Do I have a response from the people?
I have no objection to the GPS. I believe the reason for the bond being set the way it was because the defendant does have prior failures to appear on other cases. So there was a flight concern, but I feel that with a GPS tracking tether that way.
How many prior fire failures to appear?
I believe that she actually has 2 misdemeanors in front of your honor. One township, one state case that she was here over a year ago. I don't know if those are set for another trial or pre-trial date or arraignment date yet. I believe there's CCH also indicates that there was a failure to appear on, I want to say it was 33rd district, but I can double check that. But there's 3 failures a failure to appear on 3 different cases.
And Judge, I could briefly reply to that.
Go ahead.
The 33rd district, it looks like that case is not in play anymore. I did call them up. I do know there's been some issues, but I also know she's been sitting for 12 days. I just got this file. I intend to get everything wrapped up into one. She does need to pay the restitution. I also did a bond memo.
A drug issue involved in this?
Not that I'm aware of, Your Honor.
Or a substance abuse issue? Because the magistrate set the bond at the 10,000, 10%, and indicated consider release to treatment. Does anybody have anything of a substance abuse history with this defendant?
Nothing in the court system. Yeah, Judge, to my knowledge, there's nothing in the court system about drug use.
What?
Nothing in the system about drug use in the court system. I don't know what she's done in her personal life before I got involved, but I have no notes on that.
Well, somebody needs to check into that. There's a reason why the magistrate indicated that. I would sign an order for her release to treatment on a PR with a GPS tether, which is what's set. That may be appropriate in this case. Certainly I'll address it again on the 16th. But at this point, that's all I'm going to do. So our bond will continue. I'll sign an order for release to treatment on a PR with a tether.
Glad to see you.
Okay.
Be in front.
Yeah.
Court calls case People versus Jennifer Baker.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who should be in appearance via Zoom, Your Honor.
Good morning,
Good morning. Your name?
Jennifer Baker.
All right, thank you.
Your
Thank
Honor, we are
you.
just on this matter. I have been in talks with Mr. Hawthorne with regard to an offer. He advised that he just needs to check in with the appropriate individuals.
That's very true.
Probable cause conference will be adjourned April 23rd, 2026, 9 a.m. Bond continued.
Your Honor.
Thank
Court does
you.
call. Thank you, ma'am. Court calls case People versus Troy Swope. Goldstein.
David I. Goldstein appearing on behalf of the defendant.
Troy Swope. All right, what are we doing?
Your Honor, in this matter, I had spoken to Mr. Chavalowski about a resolution that I was planning on discussing with my client this morning. But as I think the court is aware, there was something intervened which prevented me from being here this morning. So I'm asking for a 1-week adjournment, but we did also address bond last week. And you indicated you wanted to see some proof or some information regarding the Suboxone regimen that he is on. I attempted to provide that to the court this morning by Zoom. Your clerk indicated, however, that it may not be readable, and if so, I can read it to the court.
It's hard to.
Yeah, my copy is a little better, Your Honor. I might be able to read it to the court. Basically, it came from Trinity Health, the group recovery medicine. They confirmed that he is on Suboxone, and they are monitoring him. There was a period of time when he was, because of his insurance problem, that they were unable to provide it, and that was when he relapsed. But he is back on he is back on the Suboxone and they are monitoring him. And that's coming from Francis Michael James at the Trinity Health IHA Medical Group Recovery Medicine.
Okay, somewhere, I don't know why Bellinger has it, but I got a good copy. He's just, because Bellinger's in everybody's business. I actually have a very good copy that I can read. You know, and it's funny, Mr. Goldstein, while he watched us old people struggle to read it, Bellinger got the good copy right here.
You're welcome, Mr. Goldstein.
Johnny on the spot, or say Jay on the spot is what I should say.
For the chip report, there's his attention. Right, but this is not indicating that he's back in treatment, right?
One moment, Your Honor. I've got to address something real quick. I'll be right back.
Yeah, I don't,
Need some music?
yeah,
Back, Your Honor.
you know, you're the only one that would ever be able to get away with that. All right. This does not indicate that he's in treatment, however. It indicates that there was, but if I'm reading it correct.
Okay, is the one you have dated April the 1st, Your Honor?
It is.
Okay. I mean, it
So
does say he
basically
assisted.
what it's telling me is that he reestablished connection to the clinic on February 25th. However, they're unable to comment on his compliance, given that he failed to follow up with the urine screen ordered on that day.
Your Honor,
So
that's,
it does,
so
he's in
there's another
compliance.
document. I'm sorry, Judge. There's another document that I have that indicates that he did appear but didn't have the money. That's why it was not completed.
Is that
This is also for Mr. Bellinger.
Mr. Bellinger has that one too?
Yeah.
Okay,
don't know
hold
if
on.
Mr. Goldstein has.
No, Mr. Goldstein is reading from his phone. I don't know why Bellinger has any.
Your Honor, his family's here and has.
Oh, and they're handing you stuff? Why didn't you tell me that?
Your Honor, I didn't.
You just were making it look like you were doing something. Hold on one moment, man. All right. Yes, ma'am. What's your name?
States that we didn't have the $400 for the drug testing that day, but if you look, we did reschedule it.
When is it rescheduled?
I don't remember the exact date. I went to the clinic today. And they highlighted it to show like we didn't have the $400 for it and we needed to put that.
Okay, so I get it. So there was an insurance issue. You had to pay it out of pocket, which was 400. You didn't have the 400. It's not like you didn't have $25 for testing. You didn't have $400 to follow through because of insurance. All right. Thank you, ma'am. What is your name? Because I have to have it on the record. Your name's Emily? Will that work for you? Okay. And your relation to, really? You're smiling about it. Oh, okay, never mind. What? Look at who? That's mom? Who's mom? It's Mr. Swo's mom? Okay. You like her? You do? Okay. I was just being nosy. It has nothing to do with my decision. So what was his previous? Mr. Goldstein, what was his previous bond set?
Your,
I think he
I'm at
was on
home. I don't have the file with me.
5,000 PR.
Yeah.
And then to comply with treatment. So what I will do, I'll grant well, we got to set this out. You want this set to what date, sir?
Next week, Your Honor. Next Thursday.
I'll set it to April 9th, 2026, 9 a.m. I'll reinstate the defendant's previous bond of personal recognizance, $5,000. Follow all treatment and everything. You understand that, young man?
Sure.
Yeah. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Manuel Burns House.
Here, Your Honor.
Mrs. Cannon? No, here she comes.
Good morning.
And she was late today.
Gosh.
No, she was. She was
It was
just late.
rain,
She
traffic.
said it's because it was raining and that she melts. But that's what I heard from the whole conversation. But go ahead. I'm sorry.
Morning, Your Honor. Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Stephanie Cannon.
Permission to practice is granted.
Thank you.
All right. And Mr. Barnhouse has.
Right here, Your
And
Honor.
we're requesting adjournment.
You're requesting an adjournment.
Yeah.
And you approach? Yes. All right, record should reflect we've had a bench conference in this case. Probable cause conference will be adjourned then to April 16th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case People versus Deion Baldwin.
Michael Gaddy, Assistant Public Defender on behalf of.
Baldwin, can you get somebody to unmute you and state your name? All right, stay right there, Mr. Baldwin. I'm going to pass it. I'm going to try to call another matter and then right to you, okay? Well, no, okay, good. Court calls the case People versus Jerome Adams.
Michael Piatti, Assistant Public Defender. And for the record.
Oh, Jerome Adams. Yeah, may we approach briefly?
Yes. Well, if we verify that, then I'll call the court calls the case People versus Glenn Bradford.
Assistant Public Defender Jay Bellinger on behalf of Mr. Bradford, who approaches.
Bradford.
Well,
And Your Honor, we are seeking an adjournment on this matter for purposes of negotiations, and I would also be asking to address bond. I do understand that he is out of custody.
so this could go south. Okay, no, that's fine.
Always.
Fine. I will adjourn it to April 23rd, 2026, 9 a.m. As to bond.
As to bond, Your Honor, my understanding is that this case was initially charged last September, then dismissed, and then at the beginning of March, and then recharged at the end of March. During that intermittent time period, Mr. Bradford and his wife began marriage counseling. My understanding is that she's here today and she has had an opportunity to speak with the victim advocate. My client, Your Honor, would be asking for his GPS tether to be removed as well as for contact to be reinstated. Reasons being, Your Honor, they are doing that marriage counseling. They'd like to continue to do so. And again, my understanding is that she's okay with the no contact being lifted, but I would inquire as to what Ms. Zinda thinks.
Really? You're going to ask?
I don't necessarily want to know the answer, Your Honor.
I rolled to say, is there a risk? That's okay, Bellinger. You keep wanting to go ahead. There's going to be a line today. He's going to cross it. You're really stamping on it. Ms. Zenda.
Spoke with her. She requested no contact to be removed. She said she was not afraid of Mr. Bradford. And I do understand that they are in marriage counseling, so I will leave it in the discretion.
I will add a provision of no non-consensual contact. I will delete the no contact as well as the no go to provision. And defendant's GPS tether may be removed.
Thank you very much, Your Honor.
Thank you, Your Honor. You're welcome, sir. I did it for you, not yours.
Okay, so go over to
Wait, Bellinger. You never lower a bond. I'll pay. Remember that case, Bellinger. Hear me, Bellinger?
I'm so sorry, Your Honor.
When you're up there screaming and yelling about, you never change your bond. You never for us, never do anything.
When do I remember that?
Remember, do that all the time.
Thank you, Your Honor.
That up there. Court calls the case, People versus Wardell Smith.
Morning, I'm Rob. Wardell Smith, who's approaching the podium. Wardell, would you state your name for the record? Wardell Smith Jr. Judge, this is a PCC matter. I've had a chance to speak with Mr. After discovery. We're asking you to sit for an exam.
All right, preliminary examination will be set for, will people have their witnesses available the 14th? Set preliminary examination, April 14th, 2026, 9 a.m. That is before Judge Moore.
Judge,
Yeah.
may I address bond?
Well, both of you want to address bond.
I think I should go first.
Why is that?
Because I know what she's gonna say, so I want to beat her to the punch.
Okay, go ahead.
Judge, no, not to be facetious, but
Oh.
my understanding, he's got a $50,000, 10% bond. This is incident between he and his wife, a long-term marriage. My client is asking that if the court would consider a $5,000, 10% bond tether if necessary. He's the sole support of the family. He will stay away from the marital home as for now and wants to help work with his children. His daughter's graduating this soon. He wants to be able to be there. So what we're asking for is a reduction in bond.
Response, I guess.
My attention that Mr. Smith has made, I believe, by the last check was 65 calls to the victim's listed number, which we have had contact on before from his pin since being arraigned in the jail. I and for his phone privileges and text privileges to your votes in those calls. There terms of agreement, I love you, babe, things like that. So it's a pretty good idea that it's Mr. Smith and would have to your vote this time for bond remain set, given that he has violated that bond.
Judge, if I may, I thought when I got the appointment, I was told he was out of custody. I did call the one number. It ended up being his wife. She then texted me saying that she would like him home. I told her I can't speak with her anymore about that. That's something for her to discuss with the prosecutor. But again, Your Honor, we're asking if you would please consider a reduction of bond and on tether.
I'm going to deny the request. He's violating the conditions of his bond. Or at least an indication that he has. So I'll deny the request for any reduction in bond. Bond will continue defendant's phone privileges and texting privileges are hereby ordered for vote pending a hearing. Thank you.
Yeah, come and see you. Thank you, Your Honor.
Court calls the case People versus LaShawn Charles.
Oh, no, those are people.
Really? LaShawn Charles?
Good morning,
Good morning. State your name.
LaShawn Charles.
Thank you. We're waiting on your attorney Bellinger.
Okay.
I'm not going to hear Miss Gaines. Where's Bellinger? Where is he? Where? Gee, oh, Pete, I called this case like hours ago. Oh, I called the case a long time ago and we've been waiting on you.
So sorry.
No, you're not.
I am.
No.
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Charles. Hi, Ms. Charles.
Hello.
It's already stated her name about 55 minutes ago.
Your Honor, this case is currently with Victoria Burton Harris. I have emailed her with regard to a resolution. I'm just waiting on her to get back from her leave. She is back on the 6th, I'm told. So I would just ask for an adjournment past that date. We should have an answer at that point.
Have an answer by then. All right. Probable cause conference will be adjourned to April 16, 2026, 9 a.m.
Thank you very much.
Bond will continue. Thank you, Ms. Charles, and thank you for your patience in waiting for.
Thank you so much.
Court calls case People versus Tyler Watts.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Watts in the case 25FB1347. And Sherilyn Foster Tucker on behalf of Mr. Watts in the case ending in 1734.
All right. What are we doing? Because I have a plea form in your case.
That is correct, Your Honor. And Your Honor, in my case, I just jumped into this case yesterday, so we were not able to get the paperwork in. I'm just asking for a brief adjournment so we can finalize a plea agreement.
On this case?
It makes sense. I don't.
Go ahead.
If we PD case today or we can adjourn both, they could be on both. Sure enough.
Is he being held on anything else or?
Yes, Your Honor, he's being held on a violation of probation in circuit court, but Mr. Watts indicated to me he believes he has a release to treatment on it. Oh,
That, I'm sorry.
but he believes he has a release to treatment on that file.
Okay. I normally wouldn't do this, but I don't know. Ms. Foster, are you, that's a guilty to a misdemeanor of some type? That what it is?
Yes.
And does he wish to do that? Or, okay, if we can. Okay, I normally wouldn't do this, but if we can get the paperwork in, let's try to take care of it today, get it done. Unless somebody has an objection to that.
Oh, that's fine.
All right,
No problem with that.
all right, so I'll pass these matters. We'll take you back and we'll get you out here to try to get it done. All right, young man?
All right, thank you.
Oh, another young man. Joe Simon. Huh? Yeah. Oh, good morning, sir. It's a pleasure seeing you.
As well.
Dr. said he didn't want to talk to you. He told me that early today.
Well, I can tell you that he never responded to my reach out yesterday.
See, that's what I'm telling you. So why'd you bum rush him like that? All right. Okay. Oh, all right. I don't want to get into that between you two. I'm done. Court calls the case. People versus Danina Combs.
Frank calling on behalf of Ms. Combs, who hopefully should be on Zoom.
Morning, Mr. Bull. Oh, well.
Awesome.
Yeah, I'm here.
Hold it.
All right.
Hold it. It's a phone call.
Yeah.
Your name?
Danina Combs.
Thank you. Phoned in. That's why.
Yeah, great. I'm glad she's here. Your Honor, I spoke to Ms. Combs yesterday. I also had some discussions with Mr. Childred. We're looking at possible resolution options of this matter or these matters, if you will, and need a little more time.
A little more time. 23rd work for you?
Sure.
All right. Probable cause conference will be adjourned April 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case People versus Bryant.
Brian Bowling on behalf of Mr. Bryant.
Simon, put that back. Don. Your name, sir?
Man, Jason Bryan, how you doing, sir? Sorry to see you this again.
Oh, why?
Just in this context.
Oh, in this way.
Yes, yes. I'm just
How are you doing?
not so pleasant.
All right. Let's see what we can do to try to get you through this.
Your Honor, I met with Mr. Bryan at the jail yesterday. We're just asking for an adjournment for some additional plea discussions.
All right. Why don't I just put it out 2 weeks, put it out to the 16th, April 16th, 2026, 9 a.m. Bond, continue.
Perfect. Thank you.
All right. Thank you.
I don't know if I'll be doing something.
Your Honor.
He's in Zoom?
Yeah.
Okay. Court does call the case People versus Orby Huffman. Your name, sir?
Orby Byron Huffman.
All right. And Mr. Huffman, you're intending upon representing yourself?
Yeah,
I'm sorry, you said what?
yes,
All right. I do have to again apprise you that you are before the court on the charge of assault of a prison employee. You understand that charge?
yes, I do.
That is a felony punishable by up to 5 years incarceration, a $2,500 fine plus court costs. You understand that, sir?
Yeah, I hear you.
You understand that there are difficulties when you are representing yourself, but I need you to be apprised that the court will treat you the same, as you won't receive any worse treatment, you won't receive any better treatment. You understand that?
Yes, I do.
And you also understand that the court will presume that you have knowledge of court procedure and court rules. You understand that? The court will not be in a position to assist you regarding any of that. You understand that, sir?
Yes, I do.
Do you still intend upon representing yourself?
Yes, I do.
I do have to also tell you that if at any time you change your mind and you wish to be represented by counsel, you just need to inform the court, and the court will ensure that counsel is appointed to represent you. You understand that?
Yes, I do.
All right. What are we doing on this case?
I would indicate, I've just been informed by several of my colleagues that Mr. Orby or Judge Conlon yesterday on a case that was represented by David Burgess referred for a competency evaluation.
Oh, he was referred for a competency in that case? Oh. Given that, would the people be requesting that I refer for competency in this case?
Because at this point, there's a question with respect to his competency, and we need to know that he is in fact competent before we vote.
Mr. Huffman, anything you want to say regarding that?
I cannot hear what he said.
What he indicated is that you were before Judge Conlon, that you were referred for competency on that case. And that then a hearing was set. I then asked whether or not the people would also be requesting, given that information, that you be referred for competency on this case to make sure that we can proceed forward. The people have made that request. I then asked whether or not you had a response to that.
I feel like I'm capable of representing myself.
All right, thank you. Given the information that has been provided regarding a competency evaluation, the court will order on people's request a competency hearing, a forensic evaluation. I'll set a competency hearing for July 2nd, 2026, 9 a.m. And Mr. Childers, I will need an order. All right. Bond will continue. Thank you, Mr. Hoffman.
What is bond?
I'm sorry?
What is my bond?
Your bond in this case, as set, is $50,000 cash surety.
Is that 10%?
No, it is cash surety.
Thank you.
Thank you. Court does call the case, People versus Daniel Haynes.
Assistant Public Defender Davi Lebo for Mr. Haynes. Haynes, can you tell the judge your name, please?
Daniel Haynes.
Thank you.
And Your Honor, we'd like to set this matter for preliminary examination, please, and discovery is complete.
All discovery is complete.
It is, Your Honor.
People have their witnesses available the 14th. Preliminary examination in both of these matters will be set for April 14th, 2026, 9 a.m. before Judge Fleischer.
Thank you, Your Honor. I just want to briefly address bond.
Go ahead.
Mr. Haynes indicated to me that he was not able to appear previously due to a lack of transportation. I do believe that he would appear in the future if given the opportunity.
How can you ensure that?
He's indicated to me that he has made arrangements.
Any response? I don't need a response. Motion for bond reduction is denied. Certainly Judge Fleischer can take that up at the time.
Thank you, Your Honor.
Thank you. Oh. It's one of those days. Court does call the case, People versus Walter Rice.
Mr. Rubin.
Where?
Hey, Your Honor. Can you hear me?
Hello. Yes, I can hear you.
Oh, sorry about that. Good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Walter Rice, Your Honor, who is currently in Macomb County Jail and not present today. He didn't get picked up, Your Honor.
He's in the Macomb County Jail?
Correct, Your Honor. I believe he has a parole hold. I am figuring that out. I was informed about that. What I did want to do today, if it's acceptable, is just, I guess, set this matter for exam. I believe he did have a PCC prior. I am in receipt of all discoveries.
I don't know how we do that. He's not here. I mean, he was in our facility and now not, correct? And you're saying he's in Macomb, but we don't have any indication other than what you're saying is that he's there. Well, here's what I'll do. I'm going to adjourn this out a couple of weeks. We'll figure out where he is, and then we'll figure out how we're going to proceed from there.
Okay, thank you. I understand. I know it's a bit confusing, so I appreciate that, Your Honor.
It's a bit confusing. All of your cases before me are. No, no, I did. Now that was so wrong of me to say. My apologies.
But still somehow correct, honestly. So I appreciate you.
16th, bond continued. Thank you, sir.
Have a good one.
You too. Court does call the case. The People versus Anjanae Cummings.
Jeez. Veronica Glenn, on behalf of Ms. State your name for the record, please.
Ajane Cummings.
Your Honor, our client would like to enter a plea. You should have the paperwork.
Judge, that is probably my fault.
I'm sure it is.
No, really, it was Deputy White's fault, Your Honor. When I tried to go.
You're just talking to stall for time. What are you doing?
But yes. Ms. Cummings, did you sign this piece? They didn't, I tried, right? I didn't sign it. It's in this, you know, discuss.
Yes.
Okay. You're disturbing the peace, okay?
Today.
And you're pleading guilty. You gotta tell the court what you did. But not yet. He's gonna ask you. Sign this one right here.
Really?
I'm sorry, Judge. So Miss,
Got blamed to death.
because he was like, Stephanie, no. And I was like, right there. I was like, and there you have it. All set, Your Honor. Thank you.
I finally have before me a plea form that indicates that the defendant was pleading guilty to the added count 2 of disturbing the peace, the 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct.
That is correct.
May I have her sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Ajane Cummings. Could I say what happened?
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Okay.
You understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
You understand that?
Yeah.
Okay. You pause. Do you have an issue with that, or
What court is that?
what court is that? It's part of my court, but Judge Barr is the presiding judge there. It's a court in Ypsilanti.
Okay.
Okay, you understand that?
Okay. Okay.
All right. Understanding all of that, do you still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights? All right, on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
March 5th, 2026, at the location of 420 Emmett Street, City of Ypsilanti, Washtenaw County, State of Michigan. Were you out in public at that time?
No,
All right, what happened?
I was in the house, and the officers got told to come in, and I was, like, I was running my mouth to them, disturbingly, and they was like, "What's going on?" And I refused to get arrested. So
Okay.
they had to put.
When you were doing all of that, at some point, it became loud enough to to
Yes,
disturb the peace and repose of the area surrounding you?
yes,
And you could hear it outside at some point?
yes, because I end up going outside and,
And you were yelling?
yes,
Yeah, okay. All right. Ma'am, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of your sentencing, misconduct is defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
Keep us satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2, count 1. That's the pre-sentence investigation and report is ordered at 14H probation. Sentencing will be April 15, 2026, 10 a.m. before Judge Fox. All right,
But if I could address bond.
why?
I already posted.
I
You
don't
already posted it?
Yeah,
Perfect.
say yes.
I'm sorry, Your Honor.
I just,
Didn't see it on the. Did you get out on the other case?
Yeah.
Perfect. No, never mind, Your Honor. We good. Thank you.
thank you.
oh, I guess bond, bye. Bond will continue.
Thank you, Your Honor.
I wish you could say, Miss Glenn, don't let her come back up. The court calls the case, People versus Eric Mayfield.
Andrew Children's prayer on behalf of the people.
I'm so sorry. Joy Gaines, senior assistant public here. Everything.
Your name, sir?
Eric Mayfield.
Thank you.
Mayfield?
You're seeking media discover.
Your Honor, we are seeking adjournment in order to get more discovery. Thank you for calling this case in the earlier timeline.
Yes, I see. April 23rd, 2026, 9 a.m. or as your invite indicates. Continue. Thank you. Court calls case People versus Larry Kasserer.
No, welcome people. Right, well, we have to pass reading, Your Honor.
Morning. Morning. State your name, please.
Larry Kazaru.
Your Honor, I was advised by Mr. Chavalowski that there may be an additional charge coming against Mr. Kasaru. He was looking into reaching out to the OIC to further information about that, but as far as I'm aware, there's nothing additional.
My knowledge, we have not received an updated information.
So anyways, we're asking for an adjournment to try to get that issue ironed out.
Probable cause conference April 16th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir.
Have a good day.
The same. Court calls the case People versus Ahmad Issa.
Your Honor, Joe Simon on behalf of Mr. And state your name, Ahmed Issa.
Thank you.
Your Honor, first things first, I don't know if the court has entered my substitution of counsel. Thank you.
Yes.
And given that, because I just substituted in, I'm requesting an adjournment of the.
That's the only reason.
Your Honor, I'd actually request the quickest turnaround because the people got me discovery today. So I'll be ready.
What do you want? 1 week, 2 weeks?
I'm here in 2 weeks. I know that, and I could do 1 week. That'd be fine.
Well, I can do 2 weeks. You haven't gone through discovery with your client though.
That's true. We literally just got it.
April 16th, 2020. Right?
How tall are you, Teresa? 6'6". Oh, just.
And I wasn't gonna say anything.
Thank you, Your Honor.
Every time I'm seeing you, I imagine you're Sue. And thank you, Bond.
Thank you.
Court calls the case, People versus Thomas Kumasaka.
In control of the on behalf of people.
Public Defender Natalie Pate, on behalf of Mr. Kumasaka, who is approaching. Please state your name for the record, sir.
Thomas Kumasaka. All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
He's pleading, this form indicates that he will be pleading guilty to the count 2 charge of use of cocaine. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
May I have him sworn?
Right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Thomas Kumasaka. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Understand that?
Yes.
You wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Question regarding those rights?
No, Your Honor.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I understand.
You understand you're giving up your right to appeal of right?
I understand.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
July 1st, 2023, at the location at 2455 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. Were you in possession of cocaine?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Sir, if between the time that I accept your plea and the time of sentencing, if you commit conduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which you have led to this?
No, Your Honor.
And have I complied with the court? Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14:1. Probation sentencing will be April 29th, 2026, noon, before me.
Your Honor, may I briefly address bond?
Right.
Thank you, Your Honor. Mr. Kumasaka is asking if the court consider setting his bond at a personal recognizance bond. He states to me that he's not on probation or parole. I believe this is the only current pending case in Washtenaw County. I will acknowledge he does have a Wayne County case where he's scheduled for sentencing on April 6th. He does understand that even if out of custody, he would need to contact probation to complete his pre-sentence investigation report and return to court for sentencing on the 29th at noon. Given the age of this case, we're asking if the court would consider a personal cognizance bond.
Well, what else does he have pending? Because his bond was set at what, 25? Well, he was on a personal recognizance bond initially. Then didn't show up in August. How did he come back into custody?
I don't have that information in front of me, Your Honor, because I know he's been in for about 40 some days. Is that correct?
48.
And he's not being held on it, but there was a case that was already dismissed, I believe, that my client indicated, a paraphernalia case. But I don't know if that's how he came into custody or not, but that did occur since this.
Didn't turn himself in.
No, I do not believe so.
Had appeared, did not turn himself in. Motion for bond reduction is denied. Bond will continue. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Douglas Crockett.
And Assistant Public Defender Natalie Payton on behalf of Mr. Crockett, who should be present on Zoom. There he is. Sir, can you please state your name for the court?
Need to unmute, Mr. Crockett. Thank you.
Douglas Crockett, good morning, Your Honor.
Good morning, sir.
Thank you, Your Honor. Thank you, Your Honor. Mr. Crockett, we do believe discovery is complete to our knowledge. He's asking that this case be set for preliminary examination.
Preliminary, will the people have their witnesses available the 14th? Preliminary examination will be set April 14th, 2026, 9 a.m. before Judge Moore. Bond will continue. That's an in-person procedure, so you'll need to come down to the courthouse.
I understand.
All right, thank you.
Thank you, Your Honor.
Oh, excuse me, Your Honor, out of curiosity, it's the 14-1A District Court, correct?
Correct.
Okay, thank you for the information.
The
have
best
a good
one. All right, take care.
Thanks, Mr.
you as
Crockett.
well.
Thank you, Your Honor.
All right, throw that out. Court does call the case People versus Leonard Logan.
And then I'll be back. Your Honor.
Senator Michael Gaddy is the defender on behalf of Logan.
Sir, what's your name?
Leonard Logan, sir.
Thank you. What are we,
We're asking for preliminary examination,
discovery is complete.
to the best of my knowledge, Judge.
No other witnesses available the 14th. Preliminary examination will be set April 14th, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Court calls the case of the People versus Wilnisha Crosby.
People.
Veronica Glenn on behalf of Ms. Crosby, who is not here because she is, oh, sorry. Oh, I'm sorry.
Go ahead.
What'd you do?
I don't know. I thought that you were supposed to say something and he was telling me I don't know, made me nervous.
You made her nervous. Did you? Made her nervous? I don't know what that's all about. Starting to act like Cannon.
Oh, no.
I know, right? Anyway. All right, Sven, go ahead.
Thanks. Your Honor, we would like to adjourn this matter because
Do you have a client?
no, I'm going to tell you why.
Okay.
She's not here because she is in the Wayne County Jail and we have,
To lead with that.
I'm sorry. I will. Your Honor, my client is in the Wayne County Jail right now, and at this time, we would like to request an adjournment.
It,
And we already have proof submitted to the court.
you have what?
Proof
Proof of what?
of her being in the Wayne County Jail.
Did I question it? What? We will. All right. Do we know how long she's going to be there?
We have no idea.
All right. What I will do is I probably should issue a bench warrant, but what I'll do is I'll adjourn this out to the 23rd, 2026. 9 a.m. If she's there, maybe we can get her on Zoom and try to resolve this. All right. Thank you. Court does call the case People versus Jeffrey McCullough. Can't speak. What's up?
An Assistant Public Defender Jay Ballinger on behalf of Mr. McCullough. In Your Honor, Mr. McCullough, can you please state your name for the record?
Chef McCullough, morning, Your Honor.
Good morning, sir.
Your Honor, I will state on the record that there are no offers at this time on this matter. As such, we are staying the course and asking to set for a preliminary examination. Discovery is complete to the best of my knowledge.
Of course.
I'm in.
Oh, I say those funny filler phrases. That's funny. All right, stay the course. All right.
It was more for my client than anything, Your Honor.
No, I got you. So we'll set it. You have all the discovery though.
To the best of my knowledge, Your Honor.
All right. People have their witnesses available the 14th. All right. Preliminary examination will be set April 14th, 2026, 9 a.m. That is for Judge Moore.
Let's see what we can get rid of.
Bond.
All right,
Thank you.
Your Honor.
Court does call the case. People versus Philip Patrizio.
Brett. Asking, Michigan work rule 8.120.
Why do you guys make her stand all the way back there? Just no, you made her stay all the way back there and yell at me. Hold on one moment. Go ahead, young lady.
I'll start again.
Okay.
In court rule 8.120, under the supervision of assistant prosecuting attorney.
She did it perfectly. Ms. Zenda's finally letting her do things. Permission to, yes, I called you out. Permission to practice is granted.
Monica Glenn on behalf of Mr. DePricio. There we go. Can you state your name for the record?
Philip DiPatrizio.
Okay. All right. Thank you.
Your Honor, we would like to request an adjournment in this matter in order to allow time to meet with our client. We haven't been able to reach him, but we have him here today and we'll have his contact information.
But you've gotten the contact information.
Not yet, but I will make sure to have it.
Any objection, Councilman? This matter will be adjourned to April 23rd, 2026, 9 a.m. or as your invite indicates. All right. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Michael Moore. Yes.
Joy Gain, Senior Assistant Public Defender, representing Mr. Moore, who's approaching the podium, Your Honor. Mr. Moore, would you please state your name?
Michael Spencer Moore. All right, he's got other cases that he's done and they're set for the 9th.
That's correct, Your Honor.
Need all of these together, right?
That is what we are requesting.
Oh.
Also like to address bond.
That makes sense. I'll set probable cause conference will be adjourned April 9th, 2026, 9 a.m. Get all these. All right, yeah. Yes, that's the bond.
Now, it's my understanding that Mr. Moore, for the 3 new cases, has a low cash bond and a release. We are requesting that he receive similar bonds so that he can be released and in this matter as well.
What I will do is I would sign an order that he can be released to treatment on a PR with a GPS tether. And I don't need to change his bond. I would sign that order. So that I think clear the way. All right.
Thank you.
So at this point, his bond will. If you get that order to me, I'll sign off.
Thank you.
All right. Court calls case, People versus Christopher Duffy.
And then on behalf of the people.
Wow, she let her do one case.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Duffy, Your Honor. He's
One case.
as am I.
She let her do one case. Only gave her one file.
Patroness.
Like she needs to let her get out there. You know, the people that had Zenda they let her do like the whole docket. No, and look at the fine attorney she's become. I don't know why she wants to hold other people back. I'm sorry for having this conversation and everybody's listening. Never mind. Go ahead.
Mr. Duffy. Christopher Duffy.
Your new approach.
Oh boy, here we go. Oh yeah, come along. Wow.
So great. That was sworn out on Tuesday.
Like what the police agency is.
Which police agency? YPD.
Okay.
Wow,
Thank you.
that was dramatic. Court does call the cases of the people versus Tyler Watts. All three. Or two, I'm sorry.
This is like defender name. I mean, Sir Watts again, the 25 FB 1347 case.
And Sherilyn Foster Tucker on behalf of Mr. Watts in the case in 174.
And I have two plea forms in the case ending in 1734. There is the plea form indicating he's going to plead to count 3, use of methamphetamine, the 1-year offense. Counts 1 and 2 would be dismissed. And then in the other matter, the plea form indicates that he would be pleading to 3 charges. Count 2 of operating while intoxicated, that's the stated count 2. Count 3, which is a 93-day offense. Count 3, which is failure to stop at a property damage accident, which is a 90-day offense. And a count 4 of use of methamphetamine, a 1-year offense, which is an added count. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
For my case, that was correct, Your Honor.
And that is correct.
All right. May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Tyler Watts.
All right. Sir, it is this court's understanding that you're going to be pleading to 4 misdemeanor charges. Is that your understanding?
Yes, sir.
All right. In the case ending in 1347, you'll be pleading to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And also then in count 3, a failure to stop at a property damage accident. That's a misdemeanor punishable by up to 90 days, a $100 fine plus court cost. You understand that?
Sir.
And also count 4, which is use of methamphetamine. That's a misdemeanor punishable by up to 1 year, a $2,000 fine plus court cost. You understand that?
Yes, sir.
In the case ending in 1734, it's the court's understanding you're going to plead guilty to the charge of use of methamphetamine. That's a added count 3. That is again a misdemeanor punishable by up to 1 year, $2,000 fine plus court cost. Do you understand that?
Yes, sir.
I also have to apprise you that on the previous case, the 1347, while I'd be taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand all of that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
All right. To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of failure to stop at a property damage accident, how do you plead?
Guilty.
To the charge of use of methamphetamine as contained in the case ending in 1347, how do you plead?
Guilty.
To the charge of use of methamphetamine as contained in the case ending in 1734, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
All right. Need you to look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am. Probation.
Were you on probation at the time of these offenses?
Yes, sir.
All right. You understand that your entry of pleas in these cases could be a violation of that probation.
Yes, sir.
You understand that if it is considered a violation of your probation, you could be sentenced to the maximum allowable under those other charge or charges. You understand that?
Yes, sir.
And understanding that, do you still wish to plead guilty to these charges?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And also because you believe that you are indeed guilty of these offenses?
Sure.
Let's start with the case. The 14th, well, I'm sorry. You know, I told you you'd be sentenced before Judge Barr. You'd actually be sentenced before Judge Washington. You understand that?
Sure.
Still wish to plead?
Yes.
I don't know where I got Judge Barr. All right. On the date of March 7th, 2025, at the location of West Michigan Avenue and East Manfield Street, Ypsilanti Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested in some form methamphetamine?
Sure.
All right. Were you stopped by the police or was there an accident?
I believe in this case, I was stopped by the police.
All right. Were you do you know why they stopped you?
Yeah, it was after an accident. Sorry.
There was an accident? Recall what happened?
Honestly, no.
All right. There was an accident of some type and the police came to the scene. Do you recall that? All right. And when they came to the scene, were you ultimately arrested?
Sir.
All right. Were you taken to the hospital?
Yes, I was.
All right. Was there a blood draw?
Yes, sir.
Did the blood draw show either the presence of methamphetamines or its derivative?
Yes, sir.
Do you have any reason to dispute those test results?
No, sir.
All right. And on that same date, well, let me ask you this. Prior to operating that motor vehicle, you had used methamphetamine.
Yes, sir.
You knew what you were using was methamphetamine. Is that correct?
Yes, sir.
All right. And this might be a little bit harder. You don't remember the accident?
Honestly, no.
All right. Do you remember stopping at the scene of the accident?
Oh,
Do you remember driving away from the scene?
yeah.
May I word dear my client briefly?
Okay.
So, Mr. Watts, do you remember when the officer approached your car? Because did you have interaction with the officer that day where he approached your car?
Yeah.
And you were coming to?
Yes.
And then when you woke up, you saw your vehicle and realized you had been involved in an accident?
Yes, correct.
And how did you realize you had been involved in an accident?
The front end of my vehicle and the officer told me as well.
Okay. But the place where the officer came into contact with you was not the place of the accident, right? Let's do this. Do you have a part of the police report that I don't want to stop it if we can get it done. You have a part of the police report that gives me, it seems to me that what happened, but he may not remember, is that his vehicle was involved in an accident. And then at some point he left that scene, didn't report it, but then ultimately came into contact with police officers.
Absolutely, Your Honor. I can reach that police report. And yes, what happened, I think where he was hesitant to answer the scene, it was very nearby. So it wasn't technically the other vehicles involved, but yes, I can absolutely get Your Honor that police.
Well, I didn't need to know that. I just need to know he didn't immediately, he left. If I'm going to take a plea to count two, he got involved in an accident, left that scene. I don't care necessarily how far.
Absolutely.
I just left that scene and didn't report that, but came into contact with police.
Correct.
Yes, sir.
I had it read in front of me, the report in front of me before it wants to look at it.
Yeah, but that's any objection?
Not at all. Thank you, Mr. Childers.
All right. So because you can't remember, sir, you have a problem pleading no contest to the charge of failure to stop at a property damage accident?
No problem.
All right. You understand that all of the rights that I explained apply to a guilty plea as well as a no contest plea?
Yes, sir.
All right. And I think the basis that's been stated on the record is failure to remember. And so formally, I'll just ask you, sir, to charge count 3 of failure to stop at a property damage accident, how do you plead?
No contest.
All right. And the court had reviewed the police report in that case. I think I got that. I'm going to move to the next case. We'll just find it. Ask you on the date of April 24th, 2025, at Michigan Avenue near Platte Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, sir.
On that date, had you used it? Did you know what you were using was methamphetamine?
Yes, sir.
Now, sir, I do have to advise you that, just correct my plea form here, that was good. You have to advise you that between the time of my acceptance of your plea and the time of your sentencing in either of these cases, if you commit misconduct as defined under the Michigan court rules, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand?
Yes, sir.
Is counsel aware of, in either case, of any other promises, threats, or other inducements which have led to a plea?
So, Your Honor.
No.
No, Your Honor.
And have I, on both of these cases, complied with the court?
Yes, Your Honor.
Yes, Your Honor.
In the case ending in 1347, court will accept the defendant's pleas of guilty to counts 2 and 4 and no contest to count 3. Count 1 is dismissed. In that case, the pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 30th at 10 a.m.
April 30th, 2026, 10 a.m. That's before Judge Washington. Bond on that case will continue. In the other matter, get my paperwork here, court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
April 29th at 12 noon.
April 29th, 2026 at noon before me. Bond will continue in that case. All right. Thank you.
Your Honor.
Thank you, sir.
Thank you, Your Honor.
We got through it. Court does call the case of the people versus Juan Edison.
Your Honor, reading the code for the people.
Who? Ms. Gaines? Edison? No, it's okay. I'm sure Mr. Bellinger was tracking.
I think I was.
So it was. Oh, go ahead, Mr.
Joy Gaines, Senior Assistant Public Defender representing Mr. Tuan Edison. Your Honor, Mr. Edison Tuan Edison?
Yes.
Did call our office. He resides in Detroit. He is waiting for his ride. He asked for an adjournment. So we would ask, he asked that you pass it to the next. Well, I'm asking that you pass it to the next block, or in the alternative, may we please have an adjournment?
Did Bellinger tell you to do that?
No, he gave me other good advice.
For you, Ms. Gaines, I will pass it.
Right, thanks.
Sure, he's on his way.
He was still waiting for his ride when he called just a few moments ago. So his ride is supposed to be coming to pick him up.
Bellinger's not doing anything. Send Bellinger to pick him up.
Okay,
Okay. All right. I'll pass it to the next.
okay, all right, thank you.
Court calls the case, People versus John Mulder.
Brian Bowling on behalf of Mr. Mulder. Hey, John. Can you just state your name for the record, please?
John Mulder. Thank you.
Your Honor, I'm asking for an adjournment. I'm still waiting for some video from the prosecutor's office with respect to the incident. And then I also submitted an investigator request through my office to hopefully get some additional video. So we could.
Pardon?
Another date if we could.
Yeah, not a problem. I would normally put it out to the 16th. And I need longer than that.
Probably.
Okay. Well, is he being held on anything else?
Yes, he is.
Okay, got it. Probable cause conference, I'll adjourn that to then the 30th. April 30th, 2026, 9 a.m. Bond continue.
I requested all that.
Okay.
Like we
okay,
talked about yesterday. You're all set.
okay,
All right.
cool.
Court calls the case, People versus Dallas Fritz.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Fritz, who appears via Zoom, Your Honor.
Hello, how you doing?
Okay. You have a camera, Mr. Fritz?
Yep.
Oh, there he is.
And candidly, Your Honor, it has been a minute since I've been able to speak with my client. As far as I'm concerned, based on our prior conversation, he is ready for the plea today, but I would ask Mr. Fritz to let me know if he has any further questions about this plea, because if he's more comfortable adjourning so I can have an opportunity to talk to him more about it, I'd be happy to do that.
Mr. Fritz?
Yeah, is it okay? Can we, are we able to adjourn it, Your Honor, one more time?
Yeah, that's fine. We'll just hold the forum. How much? Couple weeks?
I think a couple weeks would be more than sufficient.
All right. No, that's not a problem, Mr. Fritz. We'll adjourn it out so that you can make sure you know what you're doing, right?
And Mr. Fritz, my understanding is that your out date for treatment might be on or close to the 14th of April. Is that correct?
Correct.
Okay, so but you're in California, right?
Yeah.
So after your out date, are you coming back this way, or are you still gonna?
Yeah, I'm coming back home, so.
Okay, so let's do this then. If we're gonna adjourn it out, 14th. You think you'll be back here by the 23rd?
Yes, Your Honor, I will be back by the 23rd.
Oh, let's do it this way then. I'll adjourn this probable cause to April 23rd, 2026, 9 a.m.
Thank you very much, Your Honor. I appreciate that.
Bond, continue. All right, Mr. Fritz, take care.
Thank you, Your Honor. Oh, I have a quick question. Do I need to bring any paperwork that you need that proves I was in treatment or anything like that? Because I can get that stuff.
Okay, you should probably have that with you so you can give it to your attorney.
Okay.
Okay?
All right, thank you.
You're welcome. Court calls case People versus Michael Agbana.
For defending, Your Honor. Mr. Ogbana is approaching.
Your name, sir? Michael Agbana. Thank you. All right.
Your Honor, we're asking for an exam on this matter.
Summary is complete.
Yes, Judge.
We'll have their witnesses available the 4th. Preliminary examination in person will be set April 14th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Jason Haas.
Stephanie Han on behalf of Mr. Haas. Mr. Haas, could you please state your name for the record?
Jason Haas.
Why are you up here?
I wanted to do something.
Why?
You're not taking that from me? Judge, please. Don't blame Mr. Haas. Oh, yeah, have touch part. Your Honor, we're just asking for a permanent matter. There is a plea to be had. It was made this morning. My client is going to avail himself of the plea, but we just need to get the paperwork to the court.
Paperwork in.
Yes.
All right.
Your Honor, when appropriate, I'd like to talk about bond in this case.
Probable cause copy. Sir, I'm gonna adjourn your case out a couple of weeks so they can get the paperwork to. Sir? I'm gonna adjourn it out a couple of weeks so they can get that information. April 16th, 2026, 9 AM.
Thank you, Your Honor.
You're welcome. Esteban.
Your Honor, Esteban, right now my client, in regards to this case, it started a while ago. He was convicted in Monroe County for count 1, which is how we got to our plea. But he was in jail for 6 months and did probation, and now he's here. Right now, he is
Hold on.
the
They
act.
charged it in another county.
Yes.
What is this count 1?
Yes.
Got it. Okay.
He pled to it, and so he had to do jail time. He had to do testing. He had to go through sober living. He did all the stuff associated with it. Right now, he is being asked to drug test and come back up here to do a lot of things that he's kind of completed already down in Monroe County. He understands that he'll be on probation here, but he's asking if we could at least make it so that he's either just doing the sober link or testing at community corrections. The financial cost of it is quite a strain on him because.
Well, I'm not following. So what is he currently doing you said Monroe, right?
Your Honor, because of the age of this, he completed what he needed to do for Monroe. He did everything that they asked. He was recently successfully discharged from Monroe.
I was sentenced to 300 days.
Yeah. And so.
Incarceration.
And so the only thing he's asking for on today's date, is that we could make testing less.
Could I do the random drug tests and not?
Hold on. She's doing okay. You don't need to help her.
It's fine.
Response from the people. So. So currently, what is he doing testing wise?
He is has to do the sober link 3 times.
So my question is because there was what was his BAC on this case? Allegedly.
The drug intoxication of methamphetamine and fentanyl.
Right, but I'm looking at the complaint. It says a combination of alcohol. But if you're telling me there was no alcohol, then I'm not understanding why he's on a sober list.
It was just drugs.
That's correct. It was just drugs.
Okay, then the complaint says something I got. Okay, so what I'm gonna do is I will grant this and defendant the sober link testing is removed.
Thank you so much, Your Honor. We appreciate that.
Thank you, Your Honor.
You're welcome. Do you have the device with you now or no?
Yes, I do. It's in the car.
Okay, so we should be able to get this over to him. You can return it so you don't get charged another day.
Okay.
All right.
So just go drop it off there.
Thank you.
Like an hour. Thank you so much, Your Honor.
We're gonna let them know you're on your way over there.
Yes, thank you, sir.
Court calls case People versus Hubert Price.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Don Filipo for Mr. Price, who is approaching. Press, can you tell the court your name, sir?
Hubert Earl Price. Thank you.
And Your Honor, I'd like to set the matter for preliminary examination as well as address bond, please.
Said all discoveries complete.
It is, Your Honor.
We'll have the witnesses available the 14th.
For best, Your Honor.
Preliminary examination in person will be set April 14th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Your Honor, I did want to address bond request.
Go ahead.
Your Honor, Mr. Price has been in custody for, I believe, the past 26 days. He's attended every hearing in this matter aside from the 129 hearing that led to his incarceration when he missed it. What he's explained to me is he mistakenly believed it was on Zoom and that his sister, who generally provides him transportation, was told that she did not need to be available that day. He did explain to me that he's confident she's going to be able to take him to all hearings going forward, where he does have verified contact information with him, and he does have housing in Saginaw that he can return to. Additionally, I would note the case from 2021, and Mr. Price has not been in legal trouble since then.
We'll come this forward.
You said there's nothing else holding him.
There's nothing else holding him, Your Honor. If you could pick up arms.
Any response from the people?
And just a quick second, there's nothing else in the next deal. I apologize. Folks have
No, it's okay.
I don't have any judges who are released to treatment here. I do have concerns given the nature of the allegations here, specifically the quantity, well as this prior which does have priors for possession of narcotics as well as an armed robbery, but that armed robbery been incredibly little, dating back to about 1972. But there's been a pretty consistent string of criminal history between that armed robbery in 1972 up to about when this occurred in 2021. I admit I don't see anything since 2021, but I have concerns given incredibly lengthy history.
Right, but he was on a PR. There were about 5 or 6 plus hearings. He appeared at all of those hearings. The end of January, he doesn't appear. So quite frankly, the court's major concern is not so much his criminal history. Given the fact that he was on a PR, it's just his failure to appear on that day. And now this matter being set for preliminary examination that he does. What I'm going to do in this case is I'm going to grant the modification for bond. I'll reset his bond with its conditions back to a personal recognizance, a $5,000 personal recognizance bond. I will indicate, however, that the defendant will need to be placed on the GPS tether prior to his.
Thank you, Your Honor.
And Your Honor, which judge was the example? I got the date, it's not the judge.
Judge Moore.
Thank
You know,
Yes, location tracking.
when they can do the test.
Thank you.
You're welcome. Court calls case People versus LeVon Jones.
Your Honor.
Assistant Public Defender Don Lee before Mr. Jones.
Your name? All right, what are we doing?
Your Honor, I've been requesting an adjournment in this matter. We're still discussing discovery.
Without objection, probable cause conference will be on April 23rd, 2026. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Landry Carey.
Good morning, Your Honor. Joy Gaines, a Senior Assistant Public Defender with and on behalf of Mr. Terry.
Your name?
Little Andre Ferry.
They really named you Little Andre? Like that? That's funny. I mean, that's a great name. That's what I mean. Go ahead.
Your Honor, I believe you should have a green sheet from us. We are requesting
I did.
an adjournment so that we can receive some media that we are to receive some additional media and also to try to work out a global resolution for his other cases.
So he's got other matters.
That is correct.
All right. I don't mind granting the adjournment. Do we have any indication as to when these other things are set? Or
Yes, Your Honor.
I'm just looking at
Yes.
timing.
He has a retail fraud third in the 14A3 court that is scheduled for April 6th.
Okay. So you're looking to wrap that with this.
That he also has some pending matters in 15th that he was just on yesterday
Okay.
that we also hope to work on. I do not have the new date for the ones in 15th yet.
What I'll do, I'll adjourn it out to the 16th, 2026, 9 AM. And then hopefully we can wrap those up or do whatever you're gonna do by that time. All right?
Thank you, Your Honor.
All right. Carrie, thank you. Court calls case People versus Lamine Pava.
Your children's hearing on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Kaba, who's walking up, Judge. State your name, Mr. Kaba. Amin Kaba.
Thank you.
Your Honor, we're asking for a brief adjournment. Mr. Kaba has cleared the first screening for the mental health report. He needs to be screened by CMH. I was in contact with them earlier this morning. They said that 2 weeks would be more than ample.
For
Yes.
next, oh, gotcha. Okay. So I'll set the probable cause. I'll do April 23rd, 2026, 9 AM in case there's some hiccup. Just try to get it done. All right. Thank you.
Thank you. For the seat, I'll give you a notice.
Court calls case People versus Devon Thompson.
Your Honor, bring the book for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Thompson, Your Honor.
Your name, sir?
Davon Thompson.
Thank you. What are we doing?
Your Honor, my office had a conflict. We did submit a motion to withdraw. We are in the process of trying to locate, or we're doing a new a motion withdraw. We're trying to find someone on the panel who is able to take this file.
Okay, but why, we don't have that now?
We do not have that now. I just,
Walks out of here without knowing who his attorney is?
that is,
I get a PR.
yeah, that's correct, Judge. We did submit the paperwork.
Problem is, he's here on a capital.
Yeah,
And
exactly,
I
Judge.
mean, I want to make sure he has an attorney, so let's do this, and I hate to hold the jail up, let's take him back. See if we can get that accomplished,
Thank
so that
you.
he can come back out and I'll let him know who his attorney is.
Thank you, Your Honor.
All right, for the passes. Court calls case People versus Preston Kelly.
Your Honor, Raymond Cook for the people.
Brian Rowley on behalf of Mr. Kelly. State your name for the record.
Preston Kelly.
Thank you.
Judge, we need some more discovery of this man. Well, Mr. Cook's looking into it. Hopefully we'll get it resolved. So if we could get a brief adjournment, please.
Probable cause April 23rd, 2026, 9 AM. Continue.
Perfect. Thank you, Your Honor.
Court calls case People versus Awastan.
People.
Probably I'm not pronouncing that first name correctly, but
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Khan.
her name?
A vase gone.
A waste,
A vase.
a base. I'll probably mess it up again. Right. All right, what are we doing?
Your Honor, we are requesting a preliminary examination for this matter.
Discovery is complete.
That's my understanding.
And would people have their witnesses available the 14th? Preliminary examination in person, April 14th, 2026, 9 AM. That is before Judge Freshour. Found continue.
On top.
Okay, just a second. Court calls case of the People versus Cameron Larry.
Ellie's on behalf of the people, Your Honor.
Assistant Public Defender Dante Lebo on behalf of Mr. Larry.
Name?
Larry.
Thank you. You're looking for an adjournment?
I am, Your Honor. We're requesting some media.
You may.
Your Honor, came to my attention, while the defendant was in custody, he made 3 calls to the victim from his PIN to her listed number. In those calls, he says things like, I'm in jail for 3 days, I've been here every day, what his bond is set at. He also states things like, we really can cut all that shit out. We can work separate ways. Do not send me to jail. I will not put you here. I know you still got some type of love for me. You're not going to press charges, but I know you really don't want to see me rot in jail. Might not want to be, might not want to talk with me, but I don't believe that. Right, so you're about to keep me in jail for real. You're going to send me to jail for 10 years. Anybody you in your on your face, I was just childish. I apologize. Kept talking about the case, talking about you're keeping me in jail. Are you really going to press charges on me? And so at this point, I'm going to ask him if you're admitting he violated his bond. He's called for after he was arraigned and told not to have contact with her. And he did have contact with her, talking about the case, talking about keeping him in jail, and like that. So I have concerns. And like from the hearing that started to violate his bond.
Response, Mr. Allen.
Your Honor, Mr. Lair's indicated to me that these calls would have been made prior to the arraignment. I understand.
It would have been made prior to his arraignment?
That is what Mr. Lair's indicated to me. I haven't been able to verify that myself.
What's the date of the calls?
And calls are from 26. And one on 325 that was later in the evening. After he would have been arraigned.
I did discuss it with Mr. Lair. He does understand that.
Still want to keep representing to the court that they were made prior to his arraignment? What?
Oh, Your Honor.
Yeah, because that wasn't true. All right, go ahead, counsel.
Your Honor, all I can say is that Mr. Lair did indicate to me that he believed they were prior to his arraignment. I'm glad that he's.
Seriously? No, he didn't.
I'm glad.
Just saying that.
Yes, I'm glad.
Just got you to just say it.
Yes, and I'm glad that he's now come clean about that. He certainly understands that he cannot have contact.
She has to check any text. Wait a minute.
That's gonna help.
Anything else?
I have nothing to add, Your Honor.
People's motion to modify bond. It's granted. Defendant's bond is hereby ordered the above. Defendant's remanded back to the Washington County Jail Court. They will also order that his phone privileges and texting privileges are hereby ordered the above. Defendant's remanded.
Thank you, Your Honor.
16th. Court does call the case of the People versus Christopher Duffy.
And then I would have to speak with her.
Michael Gaddy, assistant prosecutor on behalf of. Okay.
Okay. Mr. Duffy. Family paperwork here. All right, this is on a new case. This is the case number on this is 26F20276.
And Your Honor, on that new complaint, I think this was charged back in October, so I think the code for the count 2 is in question 750.815.
For count 2. Oh, 815. Got it. I'll make that correction to the information of this. Sorry. Sir, you are before the court. This is an arraignment on this case. The alleges that on or about September 14, 2025, location of 118 South Grove Street in the city of Ypsilanti, that count 1 alleges that you did commit the offense of assault with intent to do great bodily harm less than murder or by strangulation. You understand the nature of that charge, sir? Yes, sir. That's a felony punishable by 10 years incarceration, of $5,000 fine plus court costs. Count 2 is aggravated domestic violence, 3rd offense. Do you understand that charge? That's a felony punishable by up to 5 years, $5,000 fine plus court costs. You understand that, sir?
Yes, sir.
Count 3 is the offense of child abuse, 4th degree. That is a misdemeanor punishable by up to 1 year or up to 5 years probation. You understand that charge, sir?
Yes, sir.
All right. Count 4 is the charge of malicious destruction of personal property, $200 or more, but less than 1,000. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir? First question I have for you, and I'm sure you want to be represented by counsel, correct?
Yes, sir.
All right, this is public defender case.
Yes, I'm Michael Gaddy, Assistant Public Defender on behalf of Mr. Duffy, Your Honor. In terms of the arraignment, we'd stand mute.
Defendant having waived formal reading, standing mute. I will set his.
Your Honor, we have had a chance to discuss this matter with Mr. Duffy. He has another matter that's up for PCC today. If the people are in agreement to waive the PCC in this matter, we'd ask that both be set for exam.
All right.
And Your Honor, I do believe the discovery on the new file should be over to Mr. Garrity in a relatively quick time frame. I also got a word back from my email I sent today, and I should have that body worn camera that we were missing on the other case to him by tomorrow.
Got it. Okay, that's right. That's what we're gonna try to do on that. So what I will do on this case is that waive. I will further indicate that discovery is complete because you're getting it over there. And would the people have their witnesses available the 14th? I will then set this matter, the new case for preliminary examination for 29 a.m. before Judge Moore.
Your Honor, if I could be heard on a bond.
Yes, go ahead.
Mr. Duffy has recently secured a new residence in Toledo, Ohio. He has a prohibition against leaving the state of Michigan. We'd ask that he be allowed to reside at the Toledo address. I do have it. I can give it to the court.
As to where he is.
Correct.
Okay. All right. On the new case, I'll set his bond at a $25,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. You're not to, I will order this and then I'll change it. So don't panic yet. I'm going to order that the defendant is not to leave the state of Michigan without permission of the court. I will also indicate the defendant is not to purchase, possess a firearm, ammunition, other dangerous weapon, or anything fashioned to be a weapon. You understand that, sir?
Yes, sir.
You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You understand that?
Yes, sir.
You are to have no contact with Ebony Thoreau whatsoever. Do you understand that, sir?
They allow me,
Except with a civil standby.
they allow me contact with her because she contacted them and asked, can I have contact? That's why I can go around her on GPS, tell her no.
I thought there was.
Go back to the magistrate when I got arraigned on the case.
Yeah, I mean, we approach.
or not to attempt or have any direct or indirect contact with Ms. Sorrell, either in person or through others, or by electronic communication, including but not limited to phone, email, texting, internet, social media. You are also not to refer to that person online in any way. You understand that, sir?
Right.
I will indicate also that he is not to go to the 18 or 118 South Grove Street, Ypsilanti Township, because you're not to go to that address except with a civil standby. My understanding now, that's not your home address, so I don't have to address that issue, but you can't go there. You're not to violate any criminal law or personally appear at all, you are personally to appear at all court proceedings or other places as to the court. You have a place that you're gonna reside in Toledo, correct?
Yeah, see, we just had a baby, so I've been, working and helping her with the kids because, she been.
That's Miss Sorrell.
Yes.
Okay, I hear you, but where you're gonna reside is in Toledo.
Yeah.
Okay. I'm gonna add under the conditions, defendant may reside Toledo, Ohio. Okay. All right, that's on the new case. On the other case. All right, so on the new, I'm not gonna order GPS on that case at this point. I'm gonna leave the GPS on the other case. But I'm gonna change, and so that, and Mr. Gaddy, you can put your objections on, but I want to explain the court's rationale. I don't want you to have two orders, one that you're looking like you're complying with and the other that you're not complying with, right? I did, because that just it can end up being bad for you as you're trying to do the right thing or whatever, okay?
All right.
So on the prior case, that being 2243, I'm going to revoke or delete, yes, I should put. Delete the no non-consensual contact. I'll let you get it. And I'm going to add the same conditions of no contact with Ms. Sorrell and no going to the 11 South Grove. Okay.
Yeah.
So that they match. Okay. Mr. Gaddy, what did you wish to?
Oh, just to put on the record, Your Honor, there was a no non-consensual contact order in the matter that was originally up today, the 25F2 2243 matter. Again, it's a 25 case. I don't think there's been any violations, alleged violations. That's order. There hasn't been the mutual contact or the approved contact by the complaining witnesses seems to have been going along fine. The matter that was arraigned today predates the alleged date of incident in that matter. So, as I asked at the bench, we would just ask, we would request that the no non-consensual contact stay in place, given the fact that that seems to be working.
Right, and I get it. It's just, had these come in the order that they were alleged to have occurred, there would have been, that wouldn't have ever happened. And I'm not sure why it did. Why it's
Contact the prosecutor, explore that.
No, I
don't know why you weren't charged with the other.
I understand that.
Okay.
So what I got this, it's confusing at this point. Okay. So I'm just trying to simplify it for you because you're the one, if something goes wrong, you're the one that's going to get locked up. Right. So I'm just trying to simplify it at the same, and I'm not changing this condition so that the record's clear because the defendant has done anything. And I want that real clear. I'm not changing it. I'm just changing it for the reason of consistency. All right. And I'm letting, and I'm also going to add to that case, because that case also says you can't leave the state of Michigan, that the defendant may reside in Toledo, Ohio. Okay, so I'm going to let him go to Ohio, do that, just try to maintain. And I know it's not what you want, but try to maintain it for 12 days, get to your exams on these cases. Let's see what happens. Move from there. Okay.
Thank you, Judge.
Best I can do.
Thank you.
All right. Thank you, sir. Thank you for your patience, sir. All right. Court does call the case of the people versus Trisha Lopez.
Brian Bowling on behalf of Ms. Lopez, Judge.
Trisha Lopez.
We have a resolution, Your Honor. There's a signed plea, or there should be a and advice of rights.
What if I told you it wasn't?
Then something happened, but
I got it. Don't worry about it. I just,
so, yeah.
I had this plea form indicates that she'll be pleading guilty to the charge of disturbing the peace. But the 90-day offense upon her successful plea to that charge count on. That's the court's full understanding.
Defense's understanding of the agreement as well, Judge.
And ever sworn.
Do you solemnly swear affirm the testimony with the truth, the whole truth, and nothing but the truth?
Yes. Trisha Lopez.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in 14B district.
Yes.
Do you wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you are indeed guilty of this offense? On the date of December 30th, 2025 at 3375 East Michigan Avenue, lot 270, Ypsilanti Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I got in an argument and it was really late and I got loud and I disturbed the peace because people can hear me outside my trailer.
All right. Oh, I think she got everything. Ma'am, if between the time that I accept your plea and between the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I'm aware of none.
And have I complied with the court rule? Would it be proper to accept this?
Was that a source? As am I. Thanks, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be May 7th, 2026, 10 a.m. for Judge Washington. Bonds will continue.
Let me know. Let me know if you need.
Welcome.
Thanks, Judge.
Court. The next two are refusing. Court does call the case People versus Dion Baldwin. That's yours, Mr. Client's not. He's refusing to come out.
Okay, well, this kind of works out. I was gonna have to adjourn anyways, because we weren't able to see him.
Yeah. Probable cause conference will then be adjourned to April 30th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Jasmine Morris.
Thank you for calling Language Lines.
Jasmine Morris, who's on this? Just come on up here. Come on. Mr. Gaddy's in the courtroom. State your name.
Veronica Glenn on behalf of Ms. Morse, thank you. I am not sure what Stephanie wanted to do in this case.
Well, your client's refusing to come up. So since it's a refusal, court's going to adjourn the matter out.
Are you a lawyer?
I am, yes. Good morning.
I've not had you here, have I? Good to have you here. You can go talk, is this an arraignment and pretrial?
Yeah,
You can go talk to Mr. Cayley now. Is it out of Flat Rock?
that'd be great. Yeah.
Okay.
You want me to give some Kaylee now?
Yes. And you filed an appearance, correct?
Not.
All right, she'll hand you one and you just make sure you fill it out, put it in the file, okay? Thanks. Be ready, okay? John.
Yes.
What happened here?
Oh. There you go. You're good.
Okay.
I'll let her know you're ready.
Get more probation violation sheets, Sadie.
I need to make some copies.
Okay.
That's that.
Well, I don't think I have anything today.
I think it's awful to you.
I'm gonna. Loss or all of those 4 points would be added to your record. Your license would be suspended or revoked in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? Did you sign, read, and understand the advice of rights? You plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
I do.
The charge operating while visibly impaired, how do you wish to plead? On April 20th, 22 at 1:02 in the morning, were you operating a motor vehicle at or near 27067 Telegraph Road in the city of Flat Rock?
Yes.
That was a business, correct?
Yes.
What business?
Taco Bell.
And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes.
How much did you drink that day?
I am unclear, but I was not supposed to be doing it.
Do you remember?
What the BAC was, it was one was 0.18 and then point.
196. All right, why were you pulled over by the police? What happened?
I left Taco Bell and the car in front of me was visibly lower. It was around 2 o'clock in the morning. I turned my headlights off. They had forgotten an item. So I never turned my headlights back. So when I went into the gas station to turn around, the officer responded I did not have headlights on and stopped me for that.
But you did feel intoxicated?
Yes.
And again, you stipulate that the result of 0.196 was accurate.
Yes, sir.
Are you on probation or parole right now?
No.
Anybody force you to plead guilty?
No.
Plea is accepted to operating while impaired. The OWI is dismissed. Drive while suspended dismissed. I'm going to refer you for a screening and assessment. You'll come back for sentence at a later time. What do you have for me, Heather?
Any interest in court to school on this one, Judge?
I don't know. No objections.
You can't let me down.
Be-
It's not here. It's at Trenton High School.
Oh, that's I can make that.
Are you sure?
Probably.
Because I'll be appreciative if you do it. I will give you credit toward any jail, court work, or community service. This appears to be a first offense though, right? Right?
Yes, sir.
So you're not gonna go to jail, but I need you to show up and show up on time. That's at Trenton High School. Give them a map, will you? Do you know where Trenton High is? April 30, at what time does that start?
It starts at 9, so we would need him there about 8:45.
I need you there at 8:30, okay? So you can review the report. You're running a couple minutes late for that. I can't have people show up late, so it's gonna be April 30th at 8:30. I'd like you there. Go down the hall, get your notice, go over to probation, fill out your questionnaire and be interviewed, and we'll see you back here on the 30th. How's that?
Very good.
Mr. Castillo. All right, good luck. Yoletta Andrea Sharice Thompson. This is file 26F264290.
Yeah, it's EOP 82378 on behalf of Ms. Thompson, Mrs. Thompson, state your name. Elisa Thompson.
Okay, so we're setting a final pretrial. She was arraigned, it looks like, on March 9th by a visiting judge. Right?
The judge was, but I was the arraignment attorney.
Do you know who that was, Heather? Oh,
I'm
this looks
I'm looking right now, Judge.
Tabby, was it Judge?
Judge Tabby. Yeah, that makes
I was-
sense.
Yes, it was.
All right, let's do let's give them another pretrial. That's what they want. And we could probably do the 16th. You're on my docket then, right? April
so.
April 16th at what time, Heather?
We could do 10:15.
at 10:15 in the morning, ma'am. Your name again? Ma'am?
Thompson.
So you make sure you show up that day. Go down the hall, get your notice and come on back. If you have gum in your mouth, next time you won't, okay? Good luck. Thank you. Timothy Felsen. This is 26F245696.
The applicant TOP 82378 on behalf of Mr. Falzone, state your name for the clerk.
Timothy James Fulton.
All right, so for purposes of arraignment, does he stand mute, waive formal reading?
Yes, Judge.
Not guilty, pleas entered. I hope nobody's taking this as a sentence agreement. Defendant is requesting fines, costs only, no objection. You're not taking that as a sentence agreement. No,
Does it have to be?
you've got two drunk drivings. I don't know enough about them to commit to only giving them fines and costs. You got, I know they're old, 1 in 12, 1 in 14. That was a super drunk even.
Well, Your Honor, one of the reasons that we were requesting the fines and costs is because he is in AA, several of them.
But I'm just telling you, I'm not going along with anything like that unless I read a report. I don't want anybody to plead guilty here if they're counting on that. That's all. I'm just trying to be fair with you. I'm gonna order a screening report after this. Okay? So do you understand what I'm saying to you, Mr. Feldman?
The probation or the screening test?
I'm saying to you, I'm not likely to go along with this fines and costs. I don't want you to plead guilty if you think you're just gonna be fined and out of here. I don't know enough about you. I don't know enough about the case, but I see you have 2 prior alcohol-related driving offenses. Granted, they did 12 and 14 years ago, but now we've got a public intox, and I don't know what happened on this event, on this offense even. So I just want you to understand, you plead guilty. They might want me to do that, but I would count against it. Do you understand that?
Yes, I do.
So if you plead here, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
I do.
Did you sign, read, and understand the advice of rights?
I did.
If you plead guilty, you'll be giving up all those rights, and we're not gonna have a trial. Do you understand that?
I do.
To the charge, disorderly person, public intoxication, how do you plead?
Guilty.
Were you on division near Ypsilanti in Flat Rock, March the 5 of 26 at 7:37 PM?
Yes, sir.
And did you drink alcohol on that date? And if so, what did you drink and how much?
I had 2 20-ounce Miller Lights and 4 shots of vodka.
How big were the shots of vodka?
Just 1 ounce.
You had a 2.60 on this. That's 3.5 beers and 4 shots. I don't think you're getting that high if you've only had 3.5 beers and 4 shots, if they're regular shots. What did you do?
I'm sorry, they were double shots.
Okay, thank you. So you had 8 shots and 3.5 beers roughly, correct?
Mhm.
Yes?
Yes.
All right, so then what happened?
I went to pick my daughter up from her basketball practice. I was already parked and I was consuming. And then an officer or a guy came up to me and saw that I was intoxicated and took my keys. At first, I didn't know who he was, so I refused. And then I gave him my keys, and he still called the police. And then the police came, and they were going to let me go if I had a ride. My daughter had a ride, and I wanted to see where my daughter was. And I was just agitated, so I just like looked out, and I think I nudged an officer just to see where my daughter was because she was by herself.
How old's your daughter?
10.
You're driving and with blood breathalyzer result or blood draw?
That's why I'm so grateful that he stopped me. He took my keys. I wasn't going. And then I realized, I'm going to ruin my life.
No wonder you guys want me to just find some costs. This is not good. You're going to pick up a 10-year-old girl while you were over 3 times the legal limit. Are you on probation or parole right now?
No.
Anybody force you to plead guilty?
No.
That's a 1-year misdemeanor. To drive with a child occupant less than 16 while you're drunk.
Right. I wasn't driving. I did drive.
You did drive there. You weren't going to park the car and take her back on your shoulders, were you?
No.
This is scary to me. This is what I mean. Let me read the report. I'm going to accept your plea. Yeah, yeah, I'm accepting your plea. Look, how old are you?
42,
Where do you work?
Domino's Pizza,
What do you do there?
delivery driver.
I mean, you're respectful. You came with a suit on. That's more than I can say for a lot of people. Right, Ms. Patil?
Yes, Your Honor.
But we gotta get this under control. I mean, it'd be very easy for me just to find you and get you out of here, but that wouldn't be right. I'm ordering a screening, I'm accepting your plea. I'm ordering a screening and assessment. I'm gonna order that you not have any contact with prosecution witnesses. I'm gonna order that you not leave the state without the consent of the court, that you not violate a law, not even that you appear in court as directed. No alcohol, no marijuana, no illegal drugs, AA 3 times a week. I'm sorry, I want you on a SoberLink device. You're not thinking. Give me on a SoberLink device by the end of the day. Probation will explain that to you. And I'm gonna order a screening and assessment. You'll have to go get the SoberLink device today, by the end of the day. And Heather, I want an order for prints. Were you ever printed? Were you printed that day?
Yes, there was.
Yes, he was. Okay. All right, that's what I'm doing. Give me a sentence date, please. Do you want to do the court to school program?
I'm not sure. But
Okay, well, let me explain. I don't use people as examples. I'm not gonna treat you worse. If anything, you're gonna get a day credit for any jail, court work, or community service. Appreciate it if you do it at Trenton High School. I'm not gonna lie to you, it'd be more embarrassing. Here, you're gonna have 20, 25 people typically. There, we're gonna have 200, 250. I'll give you a credit, like I said, toward any jail, court work, or community service. Highly unlikely I'm sending you to jail. But I would appreciate it if you'd participate.
Okay.
You don't have to. I'm not gonna treat you worse if you don't, but I'd appreciate it.
Okay, if I get more information on that?
Sure, talk to you. You want to talk to your lawyer now?
Yeah.
Well,
I'm not exactly sure. I'm going to.
You're gonna go to Trenton High School. The court's gonna bring, it's called the court to school program. We do it in front of students. You're gonna be in an auditorium. And you're gonna come up on the stage, and I'm gonna be up on the stage, and she is, and he is, and you'd be sentenced there. And the students will file in, they'll be respectful. It's gonna be a regular sentencing, though. It's not gonna be any different, except, yeah, I mean, I don't know how to otherwise.
You'll be at high school, correct, sir?
Yeah, I'll be there. Yeah. Why, you want him to send a nice judge there that day?
You're the one.
Are you willing to do this?
Yes.
April 30th, court to school, Trenton High School. I need you there at 8:30. Please don't let me down.
No problem.
Because I only schedule 3 of these and it's quite a gap if somebody doesn't show up. So please do not let me down, okay?
Okay.
We're gonna give you a copy of the bond sheet and we'll go from there. And then you're gonna go down the hall, get your notice. Do you know where Trenton High is?
I can find it on my GPS.
Why don't you print them out a map?
Yes, I also
And-
have the address on the notice. Judge.
And then you're gonna go back over to probation, fill out a questionnaire and be interviewed, and then they'll tell you how to go about getting your silver link, okay?
Okay.
Best of luck. Thank you.
Thank you, Your
Pratt, Kevin Allen Pratt. 26F245-858 A and B.
Dion Patel, 8378 on behalf of Mr. Kevin Pratt.
All right, so for purposes of arraignment on the dryball license not valid and on the improper plate, does he stand mute and waive formal reading?
Yes, sir.
So then he's going to plead guilty now, as I understand it, responsible to improper display of plate. They're going to dismiss the original charge of improper plate. And he's also going to plead guilty to the charge of allowing unlicensed driver to drive with the driveway license not valid to be dismissed, correct? Sir, if you do that, the improper display is simply a civil infraction. You'll be fined. And on the allowing unlicensed driver to drive, you plead to that. It's 0 points. It won't go on your record. It is punishable by up to 500 fines, 90 days jail, costs are all those. And then I would dismiss the other charge. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice or rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. You understand that? All right. Any questions before I go on? To the charge, allowing an unlicensed driver to drive, how do you plead?
Yeah.
Were you in control of a motor vehicle on March the 2nd of 2006 Chevrolet that was being operated on Telegraph near Leonard and Flat Rock?
Yes.
And were you unlicensed, suspended, revoked, or denied at that time? You were suspended, correct? I can't hear you.
Yes.
Are you on probation or parole?
Yes. Done.
Were you on probation or parole on March the 2nd of 26?
Yes.
You understand by pleading guilty here, this would be deemed a violation of that probation. That probation could be revoked, you could be incarcerated on that charge as a result of this plea and conviction. You got to keep your voice up.
Yes.
You still wish to plead guilty?
Yes.
Anybody force you to plead guilty? Please accept of that charge. This is driver license not valid, it's dismissed. Again, the improper display of plate, how do you plead? Responsible or not responsible?
Responsible.
That plea is accepted, and I'm also dismissing the improper plate. I'm ready for sentence. Anything?
Your Honor, just he indicated that he would need a payment, finance, make a payment to the fines.
It's just a couple of weeks, please.
All right. Anything else you want to tell me?
No.
Sir, is there anything else you would like to say? 100 fines, 125 costs, 75 victims' rights, $50 justice assessment, 350 or 60 days. 350 or 60 days on that. And then on the improper display, 130. Your total's 480. Can you pay anything today?
Yeah.
How much?
I can pay 100 and I can pay the rest Monday since you guys aren't open tomorrow, correct?
Correct.
Yeah, pay it all Monday.
You sure? I can give you more time. 100 now, and I'll give you until the 7th to pay the rest. Okay, you pay, he's gonna pay on the B file, the 130 on that, Heather, and then he's gonna owe 350 on the other file. So you'll have to come in here with 380 after you pay your 100 today, okay? Best of luck to you. Thank you.
Thank
John, you can take him over. Why, I'm curious as to why you're waiting, sir.
Oh.
You don't have to. I mean, I'm just.
Yeah, you can go probation, yeah.
Okay, first go down the hall and get your notice, and then go over to probation. Cheryl Yvonne Carlton, 26R260085.
Yeah, for TOP 82378 on that.
Ma'am, good morning, your name? So they're charging this as a criminal neglect. Your child missing over 20 days, and she's going to plead guilty to this under section 771.1 for a period of 8 months. True?
Correct, Your Honor.
Is that what you want to do, ma'am? If you plead guilty, I'll enter the conviction. I'll sentence you. And if you're complying, at the end of 8 months, prosecutor will move to dismiss, and I'll go along with that as long as you're compliant with the terms and conditions of probation. This is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? And did you sign, read, and understand this advice or rights form here today? If you plead guilty, you'll be giving up all those rights. We're not going to have a trial then. Do you understand that? To the charge parental neglect, how do you plead? How do you plead?
You want to go say?
Well, you sound like you're asking a question. Is that how you want to plead?
Yeah, because I want to just do this and.
Ma'am,
This over.
I'm just asking you again, to the charge parental neglect, how do you plead?
Yes, yes.
Are you the parent of a Gabriel Carlton? How old is he?
So,
And did you allow him to miss more than 20 days of school?
with doctor's notes, because he does have health problems.
Ma'am, I want you to listen, and I don't have a problem if you don't think you're guilty. If you have the doctor's notes for the 20 days, or at least 17 or 18 of them, then I'm not taking this plea.
It was, Judge, it was 16.5 days. I believe unexcused, and then it was 20 days excused. And then there were a lot of tardy.
Did you have 16? Did your son have 16 and a half days of unexcused absences?
Yes, but I was.
Wait, just answer my question. And by unexcused absences, that means you did not require him to go to school that day? Is that true or false?
That was true.
Why didn't you make him go to school?
Because I was.
Ma'am, let me finish. Why didn't you make him go to school if he wasn't ill?
No, he was ill with his GI and his sinus issues. And I was following the Gibraltar school rule, their district rules. One to keep your child home from school sick. And I also told them to see doctors and got doctor's notes also.
If you don't think you did anything wrong here, I'm not gonna take your plea. This is not, we don't want to get anything over with, and that's fine. You want me to just set it for trial, Ms. Patil? I'll be happy to.
I think you should set it for trial.
Okay, here's what I'm gonna do. We are going to set this for a final pretrial. And then when you come back on the 16th, ma'am, you can think about it. You can talk to your lawyer and you guys can figure out if you want a jury trial or a trial by court. You have the constitutional right to a jury. I'll give you April the 16th.
Judge, we will not have Rockwood here on the 16th. I'm sorry.
Oh, what day are we doing?
Their next date that they're here is the 30th.
Change what?
And just do this, just we went over everything.
I'm not blaming you, Ms. Patil. Ma'am, this is the United States. I'm not taking a plea of guilty from somebody who doesn't think they're guilty and can't tell me with certainty that they are guilty and establish that through facts. If this becomes that nonchalant, we're all in deep trouble.
I mean, he has done school.
Man, they think you didn't send your child to school and allowed him to stay home when he's correct. If that didn't happen, this isn't a very good charge for the prosecutor. And you shouldn't be pleading guilty to something you didn't do. Okay? Is that fair? Okay. So we're gonna make it April 30, final pretrial. And then you guys can talk about what kind of trial you want. What time, Heather?
We can do 9 o'clock.
At 9 a.m. Okay?
That's the final control, right?
Correct. And then if it doesn't resolve then, we'll set it for trial and you guys can figure out which way you want to go with it. Okay? Thank you. Ma'am, you can go down the hall and get your notice, please. Thank you. Tariq Anthony Kuczynski,
Miss
22F237. 22F237131 and 18F228616A.
Deanna Patil, 82378 on behalf of Mr.
I
President.
remember him, and I asked for this second file because I neglected to put it on record. So on the first file, your name, sir,
It's your,
destruction of property, you want an adjournment, right?
Yes,
So we're gonna set a final pretrial on that one. Is that gonna be the 16th, Heather?
Yes, it will be.
At
10:15.
10:15, okay, sir? So you'll go down the hall and get that notice. On the other case, I neglected to put on the record that I was revoking his 7411 status. So I'm putting it on the record now. That's what I intended to do on the 23rd. He took care of it. He paid the fines. This is, of course, a 2018 case. But I want you to understand that your 7411 status on that charge was revoked, is revoked.
can you explain to me what that means? Joe?
Sure. You pled guilty on a controlled substance violation in front of Judge Kirsten back in 2020. That plea was taken under 7411. 7411 is a statute designed to give offenders the opportunity to keep the conviction off of their record by complying with probation. It's designed for drug offenses. You clearly didn't comply with probation. You weren't here for years. So that conviction, I just want to be clear, is going to go on your record. You understand?
Yes, Your Honor.
Okay, so the 7411 status on that one's revoked, conviction enter, and that's it. and you'll go down the hall and get your notice on the other case, okay?
Thank you very much, Ron.
Thank you. Good luck. Thanks a lot, Ms. Patil, always for your help. Rourke, or Roback, Timothy Isaiah Roback. Counsel, which one do you have?
Shock.
Yeah, but this young lady's been in here and it's your first time. She'll think I'm putting her at the bottom.
Yep, I was down the hall.
No. I'm talking about this. I'm talking, this is a young lawyer here that probably wants to yell at me, so I don't want to make her wait. Let me real quick take Roback. Timothy Roback. Timothy Isaiah Roback, 25F245-266. Then failed to appear yet again. Bench warrant and forfeit bond, 7,500, 10%. I'm just kidding in this counsel there. Oh, Alexis Smith, 26F2648078 and B. Come on up here with your client, please. No problem. Your appearance?
Good morning, Your Honor. Hannah Barron representing Alexis Smith, 5265.
Your name?
State your name for the record.
Another lawyer that's gonna make me feel old. Yeah, Mr. Mays and Mr. Haynes. These 85P numbers. All right, I'm just kidding. Your client's standing mute and waiving reading, right?
Yes, Your Honor.
And we have a charge here of disturb the peace. That's file A. And file B is destruction of property. So she's standing mute on both, as I understand it, and waiving reading, and then she's going to plead under 771.1 for 3 months. Is that true?
Yes.
Is that what you want to do, ma'am?
Yes.
And then I understand the MDOP will be dismissed, right?
Yes.
So if you plead to disturb the peace here, ma'am, I'm gonna place you on probation. I'll go along with this 3-month recommendation. I'll take it under section 771.1. Who knows? I might even sentence you now, depending on what I read. And if you're compliant at the end of 3 months, the case will be dismissed. Also, if you plead to that now, I'm gonna go ahead and dismiss the destruction charge. You understand that?
Yes.
All right. Did you sign, read, and understand an advice to rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? To the charge, disturb the peace. How do you plead?
Guilty.
On March 16 and 26, it looks like it's 6:52 p.m. Were you at 28503 Valley Creek Drive in the city of Flat Rock, County of Wayne?
Yes.
And were you screaming and yelling at that apartment complex, Valley Creek?
Yes.
Did this involve who was Tyrese O'Neill?
My child's father.
Okay. So this was a dispute between the two of you, right?
Yes.
Are you on probation or parole? And what time was this? It was at 6:52 p.m. about, is that correct? And you were yelling and screaming loud enough where were disturbing others in the complex? Why were you doing that?
We had a disagreement.
I know, but we can handle disagreements better than that, can't we? It
Yes.
says you were kicking his car too, but they're moving to dismiss, so don't talk about that. That case is dismissed. Was there any damage to the car, counsel?
Your Honor, again, that is being dismissed, and it's my understanding that that person is not requesting any restitution.
Is that true? Is that what Mr. Cayley told you?
Well, there's no restitution in the agreement, and it's my understanding from the reports that the person did not want to press charges.
Mr. Cayley, your name?
Roger Keeley on behalf of People City of Flat Rock. That's an accurate statement.
Dismissing this, but I still feel like I need to advise him unless he's, notify the victim on the damage, if there was damage to the car, unless he's told you that he doesn't want to appear, he doesn't want to seek restitution.
Indicated that he didn't want to press charges, Judge.
Oh, okay. Did not want to press. Okay.
Correct.
All right. Good enough. Good enough. Give me a. All right. Is your client going to grow up though?
Yes, Your Honor.
This a first offense?
Yes.
That does.
Aside from moving by driving.
Well, there's a. Does she work?
Yes, she is a licensed practical nurse, and she just finished her education to become a registered nurse.
Good.
And is pending her boards. That's what's coming up next.
Great.
Yes.
So you're not going to act like this again, are you?
Never.
All right. What do you have to say in addition? Anything else, counsel?
Your Honor, we'd ask that you sentence her under 771.1 in acknowledgement of that lack of criminal history for being 33 years old without a criminal history. And her really just wanting to move forward with her education and her career. Those are extremely important to her. And we'd also ask for fines to be at a minimum. She does take care of 2 children. And really any fines are going to be very difficult for her to meet, or she'll make every effort to do exactly what the court asks her to, but we'd ask for those to be at a minimum.
Ma'am, anything else you'd like to say?
Just want to say I apologize to my community and I am truly embarrassed that I even acted this way.
Okay, you don't have to grovel. I get it. You're fine. You're fine. I need a probationary period in 3 months here, Heather. I mean, a review date. I'm gonna place you on probation for 3 months. You cannot leave the state without the consent of the court or violate any law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm gonna order non-reporting. Okay, so you're gonna go get advised, and I'm just gonna order non-reporting here. 100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 60 in probation fees. So your total here amounts to $335. You pay that, you stay out of trouble. It's unbecoming conduct. You know that, so you're not going to do it again. Give me a date, if you would, Heather, for
That
review.
will put us to, we have July 9th.
No, because I'm only going to place her on probation for 3 months. So it has to be before April 2nd. So I'm sorry, before July the 2nd. So we're going to set it,
Well,
my
we have,
last Flat Rock docket in June.
well, I say Judge Hudson has them on July 2nd, or do you want to do it the week prior on?
No, I'll
June
do it on my
25th?
docket before that. She's not going to violate. I can tell
Right.
by listening to her.
June 25th then.
At 8:30 in the morning. You come back on that day, you pay your fines. They'll move to dismiss and I'll dismiss, okay? Now, how much does she have to pay today?
Your Honor, I think nothing today, actually. We
Tell
don't-
me when you can pay this. Can you pay 50 per week?
Yes.
You pay $50 a week, and I'm gonna begin this starting on April the 13th. How's that? And if you don't have the money, don't panic. Call the court. We'll go on Zoom, or you can walk in here, Honor, before the due date, and I'll be glad to give you an extension, okay? Wish you well. Good luck. Thanks, counsel. Nice to have you here. All right. You're welcome. Sharon Michelle Shunky, 26F245712A and B. All right. Good morning, Mr. Haynes. How are you?
How are you today?
Not too bad.
You're with stuff.
Ma'am, your name?
Sharon Zucky.
So first of all, she has a suspend, revoke, denied charge, and an operating while intoxicated, and she's going to stand mute and waive formal reading on those.
Yes.
And then she's going to plead guilty to the charge of operating while impaired, according to what you and the prosecutor worked out. And the OWI and suspend will be dismissed, correct?
Yes.
Is that what you want to do, ma'am? If you plead guilty to that, the possible penalties, I'm talking about if you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all those 4 points. License suspension or revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that? Did you sign an advice or rights form here this morning and read it and understand it? If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing at trial. Do you understand that? All right. Any questions before we go on?
Yes.
To the charge operating while visibly impaired, how do you plead?
Yeah.
On March the 15th at 26 at 12:27 in the morning, were you operating a motor vehicle on West Huron River Drive near James Avenue in the city of Flat Rock? Did you drink alcohol prior to that? And if so, what did you drink and how much did you drink?
Yes, I did. Had like 3 White Claws.
Okay. Was your ability to operate that motor vehicle impaired due to the consumption of that alcohol? And if so, in what way?
Yes, it was.
Okay, how? Why were you pulled over by the police?
Tags on my car were down.
All right. Any other reason they pulled you over other than that?
That's all the reports.
Okay, then ultimately you were administered field sobriety test, correct? And ultimately you were administered a PBT and then a intoxilizer test at the police station. Is that right? A breathalyzer.
Yes.
And counsel, what were the results of that?
We'll skip that to a point one.
Okay, and are you on probation or parole, ma'am? Anybody force you to plead guilty?
No.
Is this a first offense?
Yes.
Plea is accepted to operating while impaired. The OWI is dismissed pursuant to stipulation. The drive while suspended is dismissed. I'm going to refer you for a screening and assessment. So you're going to go across the hall after we give you your court date. You're going to go first down the hall and get your court date, and then you're going to come back across the hall to probation where you'll fill out a questionnaire and be interviewed, okay? I'm going to, how old are you?
46.
Okay, no alcohol. Here are your bond conditions. Personal bond, $1,000. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I'm not going to require AA right now. Screening and assessment. You'll fill out a questionnaire and be interviewed across the hall. They'll make a report and recommendation. She has other warrants here, right?
Those, these were the updates and the chief played these, with the last days.
Okay, okay. All right, good enough. Ma'am, do you have any questions? All right, good luck to you. Go down the hall, get your notice, and then over to probation where you'll fill out a questionnaire and be interviewed, and I wish you well.
Thanks.
We didn't do a date.
Jeez. I'm telling you, I'd look really bad if you guys didn't save me. All right, what are we doing on this one?
Do you want to do April 16th or is she interested in Porter School?
No, I think I'd want a different one. I've got a couple drunk drivers. April 16th at 8:30 will be your sentencing date. Okay, ma'am? Wish you well. Anything else?
No, you're
Good luck. Okay, let's get Mr. Cayley in here real quick. Thanks, Mr. Haynes. Teasdale, Lauren Rose Louise Teasdale, 25F245343. Good morning, Mr. Cayley. How are you?
Oh,
All right, ma'am, your name, please. Mr. Mays?
Morning, Your Honor. William Mays on behalf of Ms. Teasdale. Judge, we filed motions, a couple suppress HGN, motion to dismiss under Gallagher. Prosecutor filed a response. I filed replies as soon as I got the responses yesterday.
Heather, for some reason, I got Mr. Mays's motion, but I did not get the response or the replies. Can you make sure that those are copied for me, please? I want to make sure I read these. What day do you guys want to do? I mean, what do I have? It's kind of getting up there for me, Mr. Mays.
Yeah.
You want to do it on the, what did we set that other one, the 30th?
Well, you did that one at 1, and I think that's gonna be quick. You did that one at 1:30, so if
You want to do it at 1 on the 30th?
I've got a jury trial on the 29th, but it should be done in the day.
how about at 11, Judge?
I'll do it whenever you guys want.
What do you
You want to
think?
do it on the 30th at 11? Can you do that?
As long as I'm done with that jury.
Well, I get it. I'm not gonna,
You may get a panic call from me in the
We're not
afternoon.
gonna come get you, no.
Yeah, that's right.
no, we'll do it on the 30th at 11, but I also need to set a jury trial date in case the motion's denied. So let's set a jury trial date. I just did May 14th. How do you look May 14th, Mr. Mays?
Already got a jury trial that day.
How about the 21st? Do I look okay with that, Heather?
On the May 21st?
Yeah.
Let me take a look at that date, Judge.
You good on that day, Ms. Scaly?
May 21st.
Yeah, I just want to
Yes,
make
looks
sure.
good so far, Judge.
May 21st, we'll do it at 8:30, and then I'll just have you guys put together jury instructions. If I deny his motion on the 30th, I'll give you 10 days or so to put together your motion, your response. Okay?
And we already made the interwebs.
What's that?
You and I already up there. Judge Dad and Must Dad Mays.
Oh, jeez.
Yep.
You gotta,
What's this?
Take care.
Yesterday.
you gotta recall
That's
this.
it?
Yeah. Would he?
Oh.
Okay.
Thank you, Judge.
Have a good day. Good to see you. Alexis Smith.
They're coming back in.
What is the issue? Dean?
She wants to go up.
26F 2648078. Come on up here, counsel. What,
Come back up here.
come on up. What does she need to do?
Your Honor, she has a pre-planned trip to Disney World.
Disney World?
Yes, with her
You're
children.
going to Disney World? I don't know. Yeah, when you going?
That time.
Discovery is complete.
To the best of my knowledge.
People have their witnesses available the 14th. Preliminary examination will be set April 14th, 2026, 9 a.m. That's before Judge Fleischer.
Thank you.
Courthouse case you're welcome. Courthouse case, People of the State of Michigan versus Patrick Shaughnessy.
Michael Gaddy on behalf of Mr. Shaughnessy, Your Honor. He's here via Zoom.
Yes, sir. State your name.
Patrick Shaughnessy.
Thank you.
Your Honor, last time we were here, we started a plea. It was adjourned until today. I've discussed the matter with Mr. Shaughnessy. If the court's indulgent, I'd like to a plea.
I don't. Okay. Yes. Okay. So he wants to take the.
Yes, Judge.
All right. To the use of methamphetamine.
Yes.
All right. Now, since we're on a new day, let's do it this way. Shaughnessy, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please, sir. State your name again.
Patrick Shaughnessy.
Okay, you can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, I do.
In understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Correct, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of the rights contained on that form?
Yes, Your Honor.
Understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today? That's dismissal of counts 1 and 2 to get you to plead.
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
And because you believe that you are guilty?
Yes, Your Honor.
You understand also, sir, I'd apprised you of this before, but you understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer.
Yes, Your Honor.
All right. Sir, on the date of January 28, 2026, Liberty near South Dancer Road in Lima Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was methamphetamine or ecstasy?
Yes, Your Honor.
All right. Sir, I do have to apprise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Yes, sir. I thought that he was going to be, the people weren't going to object to 7411 in this matter.
That is.
Okay. No other promises than that, Judge.
Likewise.
And have I complied with the court?
That's what.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation is ordered at 14A3 probation. Sentencing in this matter will be
May 18th at 9 a.m.
May 18th, 2026, 9 a.m. before Judge Fleischer. Bond continue.
Thank you. I'll email you the,
Thank you.
I'll email you the contact information for probation, sir.
Court calls case People versus Laura Smith.
People.
Should be hearing advice.
Via Zoom. Ms. Smith, can you unmute and say your name? Said she's trying. I read lips. Okay, state your name.
Laura Smith.
Thank you. What are we doing?
Your Honor, we have come very close to a resolution in this matter in terms of a misdemeanor resolution with an attempted resisting and obstructing and an OWI second. We are asking for an adjournment just to work out some details. And I apologize, I did not do a green sheet.
Your Honor, may we approach?
Sure. Record should reflect we had a bench conference in this case. I will adjourn this matter to April 23rd, 2026. 9 a.m. or as your invite indicates, bond will continue. All right. Thank you, Ms. Smith.
Thank you.
Court calls case People versus Matthew Smith.
People.
Assistant Public Defender Dr. Lebo for Mr. Smith, who appears via Zoom.
Hello.
Hello. Your name, sir? All right, I got enough of that. Okay, what are we doing?
No.
I want to say it's just from the Bear potential, honestly, potential knowledge. We don't know how much longer.
Okay. Mr. Smith, when do you finish the program at Bear River, do you think?
I'm not, I'm still in the outpatient after this one, so I'm not sure.
You're not sure? Okay.
Yeah,
Let me put it out 30 days. Let's see where he is at that point. All right, I'm gonna adjourn your probable cause conference to May 7th. 2026, 9 a.m. or as your invite indicates, bond continued.
Excuse me, Your Honor.
Yes, sir.
I was wondering if it was possible, my lawyer somehow, or should I call him?
Yeah, you'll have to call him or he'll call you.
Okay, thank you.
All right. Thank
You said May 7th?
Yes, sir.
Okay.
All right. Thank you. Court call States People versus Sarah Ward.
Michael Gaddy, Assistant Governor President of the F1. This is part of the issue.
Your name?
Sarah Ward.
Yes, Parker.
Yes, Your Honor. I think we're resolved here. We just need a brief adjournment to get the plea paperwork again.
Probable cause conference April 16, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. For cause case versus Marius Warren.
Your Honor.
Veronica Glenn on behalf of Mr. Warren.
Check.
Say your name for the record.
Maurice Warren, sorry.
All right.
Your Honor, we would like to request an adjournment.
During the matter to April 23rd, 2026, 9 a.m. All right, thank you.
Thank you, Your Honor.
For calls the case, People versus Angelise Warren.
Joy Gaines, the Senior Assistant Public Defender representing Ms. Warren. Your Honor, we received the report from Community Corrections that indicated that Ms. Warren is currently in the Wayne County Jail. By the time Ms. Mackey reached out to the court, it was, because we just received it this week, it was too much for her to be here. We're asking for an adjournment.
Well, adjourn see if we can do a video read. April 23rd, 2026, 9 a.m. Bond continue.
Thank you.
Court calls case, People versus David Wilhelmi.
Good afternoon, Your Honor. Judge David Fleischer on behalf of Mr. Wilhelmi, who should make an appearance via Zoom, Your Honor.
Sir, can you state your name?
David Wilhelmi. Your Honor, I'm just seeking a short adjournment so that we can continue negotiations on this matter.
April 23rd, 2026, 9 a.m. Bond continue. Thank you,
Right.
sir.
Thank you.
Court calls the case of the People versus Ladanian Woods.
Good afternoon, Your Honor. And Assistant Public Defender Jay Bellinger on behalf of Mr. Woods, who appears via Zoom. Mr. Woods, can you please state your name for the record?
Ladanian Woods. He's waving.
That's correct, Your Honor.
Mr. Woods, are you waiving your right to a preliminary examination?
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed, that you could.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, Your Honor. What's an offer? On the record.
Yes, go ahead.
As charged under HIDA on circuit court. That is our understanding.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
I'm sorry, Your Honor. We acknowledge receipt of information, waiting formal reading, and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be for June 3rd, 2026, 1:30 before Judge Conlon.
Thank you very much.
Bond will continue.
Have a great day.
What for that one? Yeah. Yep. This is his last one? Is it?
Mr. Childers, is this your last block, sir?
I mean, I'll stick around for.
Well, no, it's okay. I just wanted to publicly say goodbye to you. And to thank you for all you've done and for all you've done for the people of Washington County. You've done a heck of a job. And for whatever reason, in saying this one, unlike the last time, I don't know that you'll necessarily be coming back to us. But sir, it's been a huge pleasure.
I appreciate it, Your Honor. It's been a pleasure, and now I'm realizing it, that I've now placed my name on the record for the last time as the prosecutor, so that's. Yeah, they'll be trusting where I go from here, but I've always enjoyed my time in this courtroom. I really appreciate it.
I appreciate it. Good luck to you, sir. You and your family. Court's gonna stand in recess.
Rise.
Thank you.
May be seated.